Mention.
May I please, Lordship? Lordship, 1 FAO number 3 of 23 is supposed to be listed today as a part hard matter in before this honorable court.
What was the issue there?
Lordship, I have no idea because I am not in the case, but it is wrongly listed in.
Oh, it has not been there. Do it then.
Wrongly
It's
listed.
not been recorded as parted, so let it be there. Proceed there. It's not been recorded as parted. That's what I am saying.
Not right.
I will not interfere. Continue with that.
Deeply.
Man, Lordship, I would like to mention item number 11, Lordship. Lordship, in this case, Lordship, I may be allowed to file rejoinder, Lordship, to bring from certain documents, Lordship, and inform the government, Lordship. NOC, Lordship. Item number 11, Lordship. Only 1 week. Lordship.
Wait. Let it reach. Any urgency? Going somewhere?
No.
Let it reach. Let it reach.
Yes,
Yes,
my lord, I would like to mention the item number 15. Yeah,
15.
my lord. This case has been, my lord, conducted by the other counsel and I have been recently file has been handed over to me recently and I am yet to go through.
You need not be here. Ask your junior to be here.
My lord.
Some orders, it's for orders. We'll pass some orders because services are not yet completed.
My lord.
We'll pass appropriate. You need not be here. Ask your junior to be.
May I, Lordship? I would like to mention item number 22.
Yes.
Kindly, this matter may be fixed on 8th of April.
Why? Auspicious day? Anything auspicious on that day? Why 8th of April? Oh, Miss Sumila has forced you to make that submission. She has forced you.
Yes.
Yes, I know that. I know. Don't succumb to such pressures. On the prayer of the Learning Council for the parties, list this matter again on 8/4/2024.
Lordship,
Okay.
item number 23, delivery of the judgment that matter. I have informed to the IOC.
You be here. Let it reach.
Yes, matter is, Lordship, I have DK Sharma, advocate.
Whoever it is, you be
They
here
told
when
me
let the matter be called up.
Yes, matter be
Called up, reiterate your prayer at that point of time.
Yes, Allah.
So this matter was heard in Raipur.
That
Yes.
Oil India,
Yes.
I have something to ask you on that. Let the matter come.
My lord, I'm praying for listing of the matter.
What is the urgency?
Urgency, there is an interim order operating since 1 year. So against that interim order, I have filed IA for vacating the interim order.
When?
The IA,
When did you file?
it's, my lord, the exact date
Now, how far back? 1 week, 2 weeks back?
no, 3 months back.
3 months back, not listed.
Not, it was listed, but it was kept for final hearing of all the matters.
Okay, next week. Lagavi.
My
Next
lord, it may be listed on 14th.
Next week, 14, we have much matters. Even division bench, some matters that they may take time.
My
Next week, you
my-
have waited
then-
for 3 months, wait for another 3 days more. Next week.
My lord, apology, my lord. My lord, the FAO number 3 was on last occasion, 7th. This was, my
It
lord,
was unfortunately not denoted as parted. So I'll not, I can't change that. Just have the hearing done, no problem.
my lord, otherwise, my lord, VC, today was supposed to do through the VC. And
I know
VC
that.
link has already been sent to of this court number 2.
उसको वहाँ पे transfer कर दे। हाँ? Transfer, he'll be transferred. So अभी बोल दीजिए transfer.
And in
Just give that item number.
court
three.
number 1, it is in item number 3, Your Honor.
Make it time being, he'll transfer the link. Okay? Senior court, it doesn't look nice. Don't do that. Yes.
Number 1,
Mr. Panning, let me just clear up the top of the list matters, then I'll come to you. Yes,
My lord,
have you intimated?
yes, my lord, as for your lordship direction, my lord, I have written letter to them communicating the my lord order passed by this honorable court. My lord, this account, but the account acknowledgement has not been received back. Yes.
When will you get it? Tomorrow? Day after?
My lord, that will be day after tomorrow, my lord.
Day after? Wednesday?
Yes,
Thursday?
Thursday.
List this matter again on Thursday. Thursday होगा आपका 14/3/20. Mr. Lampu is requested to inform the petitioners that the matter is again listed on 14/3/2024, and in the event there is no representation on behalf of the petitioners, the matter would stand dismissed for non-prosecution. I'm making you an amicus in this matter. Item number 2. Yes,
My lord, matter may be passed over for some time. Counsel for the petitioner is on its leg.
after some. Item number 3. Yes.
Please, your lord.
Yes.
In fact, the matter was dealing with by my senior AK Purkasto, but still he forwarded the file yesterday to me and I have received the file.
Oh, very good.
Yes. So he instructed me to stand before this honorable court today. This is matter pertaining to children education allowance. So I am the petitioner. So here in this petition, as per the 6th Central Pay Commission, children education allowance was not given, not provided by the respondent government. That's why I have approached before this Honorable High Court and filed this application, praying for allowing the children education allowance to the employees of the government. Here, as per the my repetition page 46, annexure B, Your Honor. So, as per paragraph 2, this is a notification of the State Government of Arunachal Pradesh of 2009. Grant of admissible allowances and schemes of SCC revised pay rules 2018 and transport allowances, the children education allowances, A and B. So on the basis of this notification, we have I filed this writ petition, and already in this regard, my writ petition was allowed in the year 2015, Your Honor. So it is admitted by the respondent authority.
Mr.
Thereafter,
Counsel, I've gone through it.
Yes.
You can come to the writ appellate order at page 70.
yes,
73 relevant. After this, what more is left? To satisfy me that.
my lord,
Page 73, single judgment interfered with.
yes.
And they were
But-
given a liberty. If they do it, they do it. If they don't do it, how can we force them? How can this court now, in the terms of the division bench judgment, enter into the matter?
But while passing the writ appellate or appeal order, in the affidavit in opposition of the respondent, page 47, my lord, page 47. It is an affidavit in opposition. This is a read order.
Hmm.
Last paragraph,
Hmm.
here is page 47. Notwithstanding the above, the state government is at liberty to implement any provisions of the Sixth Central Pay Commission as not been implemented by keeping in mind the undertaking given by it in para 8 of the affidavit in opposition.
Fine.
Para 8 is their admission
Yes.
that as and when they, the state government develop the financial concept.
Para 8 contains two parts. One is the financial constraint.
Yes,
Second is that this allowance cannot be given to all.
Right.
There are certain restrictions inbuilt.
yes.
So in that view of the matter, the best thing I can do is reiterate this, notwithstanding anything, dispose of the petition, leave it to them. Yes, Mr. Namam, why have you not implemented your plea, your own undertaking?
Yes.
Why are you putting your employees to such trouble? Huh?
The sixth pay commission that the state government should implement in toto, my lord, giving all the benefits.
Hmm.
My lord, the method pursuant to my lord financial position of the state, my lord. We have categorically said,
Hmm.
my lord, as and when that financial position, my lord, is reach up to that level that we can bear that burden, my lord, then we will implement. We have not given any 110% assurance to the petitioner, even not before the court, but we have said so, my lord, in our paragraph 8.
So this assurance is way back in
2015,
15.
15, yes.
Now
We are
8
in
years,
8
9
years,
years.
9 years.
Situation not, because we have other pay commission also in between.
7 pay commission, right, my
Seven pay
lord?
commission.
Right, my lord. But unfortunately, my lord, the financial position remains same, my lord.
That
But-
cannot be a ground. One thing, did you
But-
accept this transport allowance while you were implementing the sick pay commission recommendation?
Never, my lord,
You
never.
have not accepted?
Never, never,
Can you just show me that?
my lord.
Can you just show me that from the material on record?
My lord,
That this was only a recommendation which the state government did not accept, adopt, and would have adopted in future subject to financial condition. Can you
my,
just show me that?
my lord, paragraph 8, we have said clearly, my lord.
No, okay, read paragraph 8. It's in the judgment, page
Yes, my
70.
lord, page 74, I see, my lord. So, 57, no? I feel they have not annexed. Anyway, my lord, it is reflected in the order, my lord, page
It's reflected in the-
73, my lord. My lord, last paragraph, my lord. Notwithstanding in the above, the state government is at liberty to implement any of the provisions of 6 pay commission. My lord, liberty has been granted, my lord, that has not been implemented by keeping in mind the undertaking given in para 8 of the affidavit of opposition submitted by respondent 1, 2, 3, noted above. My lord, in paragraph 8, we have said so, my lord, that as and when, my lord, financial position comes, we better, my lord, we will implement this transportation, tuition fees, only thing. But as on that, my lord, this benefit was never granted to the state employees, my lord. However, my lord, so far, my lord, tuition fees is not granted, but book allowances, then transport facilities are there, my lord, in the school, my lord. Transport facilities are there. So what exactly they are asking for, my lord, in total, that we should be implementing the service given benefit to the central government employees, my lord. That's what exactly they are asking, my lord. And it will be not out of way, my lord. We don't have any pay commission, my lord.
You adopt.
Yes, we adopt whatever is, my lord, possible, my we adopt. We never adopt in total, my lord.
Anything on record to show that this part was not adopted? Anything on record?
My lord, that part, my lord, no, my lord. We have said
So
only
that would have-
paragraph.
That would settle the issue.
My
If
lord.
not adopted, they would have no right.
My lord, they also never, my lord, raised that it was adopted in earlier, but later it was not adopted, my lord. Right from the single bench till appeal, my lord. They never said, my lord, it was adopted somewhere in fourth pay commission, fifth pay commission, my lord. They just wanted the seventh pay commission should be adopted in toto, giving all these financial benefits, my lord. If your lordship see the affidavit filed by the state government, my lord.
Hmm.
Paragraph
Come to page 15,
page 15,
14,
14, my lord.
that is your adoption.
My lord, yes, my lord. This is pertaining to pay rebates and other my lord, benefits given to the government employees, my lord.
So where are you getting this allowance before the six CPC?
Prior to six CPC, the state government was providing
Where have you
Trans-
stated that?
transport facilities and
Where?
book
No, no,
grant.
Stanford allowance, where have you stated that? Where have you stated that, Mr. Council? Anything more? Mr. Council, anything more?
My lord, just a few words. I would like
Yes,
to
yes,
say.
why
Yes.
few words? You can have paragraphs, no problem.
As per subsection 2 of the section 46 of the Arunachal Pradesh State State of Arunachal Pradesh Act 1986,
Hmm.
that the state government adopted all the central government legislation notification in two. So as per this adaptation law,
Hmm.
we are entitled to claim the living apart the transport facilities, but we are approaching before this honorable court with a request to allow the children education allowances. So this is until and unless this is repealed or modified or this state government of Arunachal is liable to pay the children education allowances as per the notification. So this is also one notification. May I submit here? So this notification also, the state government is not following as per the adaptation law. As per the adaptation law, D, my lord, paragraph D, the reimbursement of the children education allowances for is a destitute children, and they are entitled even per month this much allowances has been given as per the central government notification. That is 16 July.
Okay, where is the similar notification with regard to six CPC?
But state
This is
government.
of 2018.
Yeah.
Where is the similar notification with regard to six CPC? Similar notification. There has to be. Office memorandum.
Well, office memorandum, yes. It is there.
Have it?
Sorry, madam. It's a file is.
You do one thing.
Acquainted.
You search, we'll take it up after some time. You
Yes,
search.
yes, yes.
I just want a similar notification if it is there with regard to the 6 CPC.
I need few minutes time.
Not few minutes, you take your time. When you are ready, just inform me. Mr. Rama, let him find it.
My lord.
Item number 2. Mr. Sona, my lord. My lord, Mr. Sona, show me one thing, my lord. It's only with regard to the placement in that gradation list, my lord. Show me the merit position obtained by you.
My lord,
This
here
list-
is very interesting, my lord.
This list that is there at page 62
My lord,
is disputed by the authorities,
my lord,
right?
my lord.
Show me something.
My lord, here is, issue is here, my lord. What happened, my lord? In 2002, my lord, when the appointment order was issued, in the appointment order, our contention is that, my lord, this appointment order has been on the basis of the merit.
Show me.
My lord, my lord.
When that is disputed, I would have to have something.
My lord, my lord, my lord. I'm showing, my lord, appointment order, my lord, will find it,
Page 24.
page 24, my lord.
I've got it. Just show me that this placement is in terms of the merit.
This is the issue. No merit list as on
Then
today.
how can we decide on this issue?
Now the issue is, my lord, is it permissible? Because, my lord,
Fine, it's not permissible.
my lord,
But thing is, if there is nothing on record to show, how can we say that you are senior or the other one is?
now the issue, that's why, my lord, my case is like that, my lord. That since, my lord, this has been the pattern, continuous tender of the state responding authority, all the appointees prior to us, since, my lord, 1997. This has been the continuous practice. This appointment order, the merit, the serial given in the appointment order has been considered as a merit list, that has been given as a seniority list. Only, my lord, they have choose the batch of 2000 only, my lord. This is very interesting.
2002.
Two, the petitioners. Now they are saying, my lord, the number one issue, the question has to be, where is that merit list?
That's what I'm asking you.
And how they can come, my lord, after 7 years, saying that, my lord, this has not been published.
No, where did you get this page 62?
62, my lord. 62. This is, my lord, through RTI.
Where is that RTA reply?
RTI, my lord, will find this page number 60, my lord, reply to the RTI. Now, my lord, will see this cannot be the merit list. Why, my lord? As under the RR, my lord, the merit list has to be prepared by the committee. And my lord will see very interesting, my lord, this purported.
Only the executive engineer signature.
No, even, my lord, this executive engineer is attested. He's not saying that he has prepared. No, who has prepared? My entire foundation of the case is that. My lord, this is 2002, the petitioners were appointed.
Yes, Mr. Tobin. Show me the basis.
Basis is the lordship.
How did you place the 2002 candidates in the gradation? Because your rule says on the basis of merit position. of-
Merit position.
Show me that.
Here, lordship. Here, lordship, if lordship say,
Mr.
So-
Sonar has just, in the dark, he has shot an arrow.
lordship,
But we'll have to see how you acted on it.
lordship,
He is just making a ruling thing. That's
Awesome.
all. Forget him.
lordship, this,
Show me.
this 2002 examination, lordship, it was conducted in the district basis, lordship. District basis.
There has to be some basis for preparation of this appointment order. Forget the gradation list. How was the appointment order prepared?
Appointment order, lordship, hold on, sir. This selection was done on the basis of the district, lordship.
Fine. Who says no? But the appointment order is made, issued by the chief engineer. So this chief engineer must have got a select list.
Correct, lordship.
In
And the select list was not on the, on merit, lordship.
How come? I'm not on that. How does the chief engineer know that these are the persons who were selected? How did he know? Tell me that basis. He has issued this appointment order.
Correct, lordship.
On what basis?
The select,
There has to be some basis.
no, the selection was done.
Where is that? How can he determine whom he should appoint?
Lordship,
Just show me the basis. You have not filed an affidavit here.
we have filed, lordship.
File. Usme. Where is your paragraph to that effect? that this was prepared on merits?
My lord, my lord. My lord, para 5.
Para 5. See the reply, para 7 of Mr. Habum Mumpa, who is the section officer, Water Resources Department.
Para 2 and para 5.
Para 7, you come to para 7 of Mr. Mumpa's affidavit.
My lord. Para 7.
Read.
The deponent makes the merits of the candidate is prepared by the selection committee, and the tentative was prepared based on the mark by the candidate. The seniority position of the have been assigned as per their merit portion obtained in the completed examination, so and so, so and so.
Para 7, your statement is that the appointment order reflects the merit position.
Appointment. Lordship,
Order reflects, come to para 7, this is your affidavit.
Lordship. Yes, Lordship. So far, Lordship, tentative gradation list is concerned, Lordship.
Was
That
prepared-
has been prepared on merit, Lordship.
So that list that is there, it doesn't have any signature of anyone. It's just the list. But you say seniority positions of the petitioners have been assigned as per the merit position obtained in so and so. The order of serial number as per merit list, hence the seniority appears to be, hence the appointed, hence the seniority position appears to be prepared as per order of serial number of appointment order. So does that page 62 merit list, madam, and your appointment order match?
No, madam. Now, what they are saying now, madam. Now, issue is after 7 years.
They said there is a merit position.
After 7 years, what they did is, my lord, when a post arose for considering for the promotional post, and these 7 years we were under the impression, my lord, the serial assigned to us in the appointment order, it will be as per the merit. My lord. Now, my lord, even assuming
How many posts were there in 2002 advertised?
2002, my lord, there were many vacancy, my lord. Only
Where is
5.
that person who has been promoted in the page 24, 25?
My
Where
lord.
does her name figure?
My lord, yes, my lord. In the appointment order, my lord, his name figure at my lord will find at page number 25, serial number 32.
Miss Tage Nenka.
Yes, yes. Now, after 7 years, my lord, for other batches, my lord, the department maintains the same position, my lord.
Yes, Mr. Tapin.
Lordship. Lordship, kindly see, kindly come to page 19, Lordship, my affidavit, Lordship.
Affidavit.
Lordship. Yes, I've submitted, Lordship, this selection was done on the
Show me the signature.
down below, Lordship.
It's the body is not only the chairman. There has to be somebody else also. Who is that somebody else? And from where did this thing come from? Where was this kept? Where is it maintained? This page 19 onwards, where is it maintained?
19, Lordship, this is for particular district, Lordship, Tirap district, Lordship.
Okay.
Page 19, Lordship. Likewise, Lordship,
I find,
on next page, Lordship will find the Changlang district, Lordship.
no. Here, or this is for different districts.
Different district, Lordship.
And the seniority is district wise.
Yes. No,
Seniority of
no. Seniority, Lordship, that will be,
state seniority.
that will be on Lordship merit, Lordship.
No. Seniority is made district wise or state. LDC?
State, common laws.
You are still an UDC, LDC. Okay, now.
Lordship,
come.
kindly come to page, Lordship. For example, Lordship, the Changlang district, Lordship.
Where?
Serial number, Lordship, page 19, Lordship.
19 years.
Lordship. Page 19, sorry, page
One side.
20, Lordship.
Page? 22.
Lordship, I'm sorry, Lordship. Kindly come to page 35. Page 35, Lordship.
35.
35, Lordship. Just an example, Lordship. Lordship, this is for is coming, Lordship. It's serial number 4, Lordship.
Hmm.
Serial number 4, one Mani Taku, Lordship.
Hmm.
He secure 199.5, Lordship.
Hmm.
And the present petitioner, he secured only 192, Lordship.
190.
Lordship. Though he secured more than Lordship the petitioner, but he didn't get place in the selection for this particular district, Lordship.
Why?
Because, Lordship, this selection was done on district basis, Lordship. Quota kept for the particular district, Lordship. And application has to be, Lordship, filed for that particular district, Lordship.
Okay.
Suppose
You mean
say,
to say
yes,
that
Lordship.
for each district,
Lordship.
posts were divided.
Quota was there. It was divided. Lordship.
And thereafter, basing on the seniority or the merit position of those
District.
is the vacancy.
Yes, Lordship.
People were appointed.
People will be.
And thereafter, all this will go before the central.
Central, Lordship.
And then on the basis of the marks, the selection was in the same time?
Lordship. Same
Time.
Same time.
Thereafter,
A common list will be
merit list
common.
will-
Yes.
Where is that common merit list?
Common list, Lordship.
This is unheard of.
This common list has not been, Lordship.
If you are doing it district wise, how
Lordship.
can the seniority be state wise?
Lordship.
If you are doing it district wise,
Lordship.
how can the seniority be? Show me the rules. Yes, Mr. Sona, where is the rules?
My lord, rules, my lord, will find, is number 28 onwards, my lord. 28 onwards. Relevant portion, my lord, page number 30, my lord.
No, wait, just a minute. The post, this is the rules, Mr. Tapin.
Lost.
Huh?
Lost.
Now, let's see how it is to be filled up. The post of lower division clerk shall be filled up from the list prepared under Rule 11.
Now 11, my lord.
9. Constitution, Secretary, Under Secretary, Group A. 11. The appointing authority shall refer to the commission committee. Committee means the committee at Rule 10. Right?
My lord.
The appropriate number likely to occur so and so, appointing the shall also indicate as well. So and so, in case of- So, how could you have a district-wise selection? In
Lordship,
terms of this rule?
Lordship, there's another Lordship notification today.
You cannot. In the select list, there has to be one select list for all our district, one selection. Maybe. Why?
One common selection list is
Where
here,
is that notification?
that is not here, Lordship.
What does that notification say? Can it go beyond these rules?
No, cannot.
Lordship, what case is here, Lordship? The petitioner, Lordship, he secured less than the private respondent, Lordship.
That's what I'm saying. That
Lordship.
basis, how are you trying to establish? It was in two different selections. How are you amalgamating those selections? It was two different selections.
Correct, Lordship.
How are you amalgamating it? The rule says something else. Rule says
Lordship.
it will be by the committee at Rule 10. You are maintaining a statewide list. Where is that gradation list here? Seniority. Okay.
My lord, Rule 14 is very relevant for me. Rule 14, my lord. Says, my lord,
Yes, appointment may be made from the in order in which
names appear in the list. Then the presumptions has to be drawn, my lord. That presumption after 7 years cannot be, my lord.
Yes.
How it can be?
But one, how could you have a district-based selection in terms of this rules, which is not permissible? Subject to my
Lordship.
How can you have a district level selection? When they say it says it should be by a vote under 10.
Lordship. Lordship, that had happened, Lordship. That
Then
had
if you go
happened,
14, then the
then-
presumption would be 14. Where is that amalgamated select list of the whole state?
the select list is not here, Lordship.
But you have to get that. Show me that.
Lordship.
Day after tomorrow.
Day after tomorrow,
Otherwise, I'm going. It may not, it will just go waste. Day after tomorrow. Get it from your department.
okay.
On the prayer of Mr. S. Thabit, list this matter again on 14, 13, 14, 14, 14, 3, 20. So Suna, let's see what happens.
My lord.
And these selections in view of your provision, get me that notification which permits you to do this.
Yes, Lordship. Say, Lordship, just assuming, Lordship, it's not permitted also, Lordship. In violation also it had happened. 7 years of prison.
No, I just want to know how you did it.
Look.
Show me that so that we can come to a conclusion to draw at least a parallel for preparation of that gradation list.
No.
Right?
No.
What has happened, we cannot improve.
Yes.
And by saying that that was a bad thing you should not have done, will take neither him anywhere or the private respondents in. We'll have to find out a way. So give us those materials so that we can apply them. Right?
Yes.
Now this,
I'll try to get
this
it because
appointments cannot be set aside.
Yes.
This has to be maintained.
Yes, yes.
So let us see how you did it.
I'll try to get it by
Please,
tomorrow.
please.
Since selection was done long time back, Lordship.
You will have to. Because you filed an affidavit basing on that.
My lord, since 2015 matter, my lord, no more adjournment after that, this particular matter, my lord.
No. Don't take my words as it is. It will immediately change. He gives me something. Be careful. No, it will take a turn against you.
Well,
I just want him to come up with something. Because this appointments, we cannot now say, oh, you have violated the rules, so everything goes. We can't say that now. So we'll have to find out something. Just get me that.
Lordship.
Till now I'm with him.
Yes.
But you give me something, I'll
But
go.
during these 7 years, Lordship, nothing has been done, Lordship, that Lordship giving him any kind of benefits of seniority, Lordship. And even he has not made to known, Lordship, that you are the senior to the private respondent.
We'll try to find out. You just give me the why you had to do it, that material.
Lordship.
And if you have a select statewide list, that one. But that list has to be signed by a committee, not by some single individual,
Lordship.
right? Just try, Mr. Taran.
Okay.
Watch out. Yes. Any notification?
Yes,
Show
my
me.
lord.
Page
Page 49, my lord.
of your writ petition.
Yes, my lord. Page 49. It's a notification of the central government regarding.
No. This is central government.
Yes.
Where is the adoption?
But the state government has not yet published any notification.
Not it. Your good name?
You they come again.
Heard Mr. Ali Kampunun, Mr. U. Deka, Learned Counsel for the petitioner. Also heard Mr. Nabam, Learned Additional Advocate General, assisted by
P. Pango, my lord.
Sri Panko, Learned Junior Government Advocate, appearing for the state respondents. Full stop. Little clear. The petitioners have, by way of instituting the present proceedings, raised a grievance with regard to non-release of allowances, namely children education allowance, traveling allowances to him in pursuance to the implementation of the recommendations of the Central Pay Commission. Full stop. The records reveal that the petition raising similar grievances had approached this court by way of instituting WPC number 410 AP of 2010. Full stop. The said writ petition was given a final consideration by this court wide order dated, judgment and order dated 10/9/2015, inter alia, directing the state respondents to implement all the recommendation oblique admissible allowances as provided in the Sixth Central Pay Commission as per government guidelines without further delay, preferably within a period of 3 months from today. Also, being aggrieved, the state respondents had assailed the said judgment and order dated 10/9/2015 by way of instituting a writ appeal, being writ appeal number 25 bracketed AP oblique 2015. Also, the division bench of this court, wide order dated 21/1/2016, gave a final consideration to the said writ appeal, being writ appeal number 25 AP 2015, inter alia, interfering with the judgment and order dated 10/9/2015 passed in WPC number 410 bracketed AP oblique 2014. Also, however, it was observed that notwithstanding the interference made with the judgment and order dated 10/9/2015, the state government would be at liberty to implement any of the provisions of the Sixth Central Pay Commission that has not been implemented, by keeping in mind the undertaken given by in para 8 of the affidavit in opposition filed in WPC number 410 AP 2014. Also, the relevant portion of the decision of the division bench dated 21/1/2016 is extracted here in below. Madam Yazir, to it, para page 70, A2, A2A. Also, the liberty as granted to the state government wide the judgment, wide the order dated 21/1/2016 in WA number 25 AP 2015, having not been implemented. The petitioner has again instituted the present proceeding, praying for the same very reliefs. Also, the respondents have filed an affidavit in the matter, and therein have contended that the allowances as claimed by the petitioner could not be implemented in the state on account of the financial restraints as being faced by the government. However, to the maximum extent possible, the recommendations of the Central Pay Commission were implemented with the available resources, funds and resources of the state. Full stop. The financial health of the state government not having improved, the decision on implementation of the various allowances, including the allowances as claimed by the petitioners in the present proceedings, could not be arrived at. It has also been indicated in the affidavit that the allowances as announced by the central government on adoption of the Sixth Central Pay Commission would be implementable in the state to the extent the state government notifies such allowances for its employees. Full stop. The implementation of the recommendations of the Sixth CPC accordingly is being contended to be understood to the extent the same was adopted and implemented in the state by the government. Also, during the course of the hearing, the learned counsel for the petitioner has placed on record a copy of an office memorandum dated 16/17/07/2018, by which the government also, on a specific query made by this court as to whether the state government had issued any office memorandum adopting the allowances, including the transport allowance and this children education allowances as recommended by the Sixth Central Pay Commission for implementation to its employees by the government of Arunachal Pradesh. The Learned Counsel for the petitioner has not been able to place on record any such office memorandum. Full stop. In view of the said position, and also the matter having been heard and concluded by the decision of this court, of the division bench of this court, while ordered in 21/1/2016 in writ appeal number 25 AP 2015, this court on the similar issue would not be in absence of any new material being placed before it, in a position to take a different view in the matter. Accordingly, reiterating the liberty as granted by the petitioner and which is again quoted here in below. आप एक काम करिए, वो आगे वाला ए तक करिए, इसको बी टू बी कर दीजिए। ठीक है, पेज 73 है, rate which is again quoted below, the writ at this writ petition stands disposed of. Can't do much more than that. Mr. Nabam has a good smile. Good. बुलाइए, क्या होगी? Yes, madam.
May I, Your Lordship? Your Lordship, the conducting counsel is on leave. Hence, I pray that the matter may be taken up after 4 weeks.
Mr. Mao,
Yes, Your Lordship.
Mr. Mao's leave application is not reflected.
Your Lordship, it is at a footnote, serial number.
Oh, yeah. On a prayer made on behalf of Mr. S. Mao, lists this matter after
4 weeks.
4 weeks on a date to be fixed by the registry. 23 or 24. ठीक है। नहीं, अब the delivery of orders. We'll have the delivery of orders then come back to you. तो बाकी का लिस्ट डालिए। Yes, who is that? Mr. Pani,
Madam,
just going through the matter.
madam.
Where is your, that lease deed?
Page 125, madam.
125. No, just be there. Just be here. Just be here. You're party respondent. Just be there. Now, the condition of this lease,
Yes,
when was the last date?
my lord.
Last date of the submission of application?
Just a moment. (24/12/2018).
Now you come to clause number 1, page 126. Although you said, they says that hereby demise onto the lessee the demise premises to hold the demise
My
premises.
lord, I understand it is not very happily drafted. But the thing is, my lord,
See,
when this lease
if
deed,
this is be so, it would give an impression that you are not in possession of the property.
I have
As
understood,
on
I have understood.
Then,
But my lord will see, when this lease deed was produced, by the time this has come into force, even if we take it in that manner, because I was asked to produce these documents. My lord, just a moment.
that means if you
By
are
this-
selected,
By this communication, 8 July 2019,
page,
or 8, just a moment, no, my lord. 18 July 2019, 104. It is in terms of this communication, my lord, this list it was furnished. I'm aware of this, but it appears to be conditional.
because that condition of the
Yes,
advertisement
yes,
seemingly is not
yes.
proof. That's the only thing against you.
But the thing is, they have not taken this into consideration. They are not saying
If it has come to our notice, we
Yes.
have to take.
But in terms of this, 18 July only I have produced. The production is at 106. It is a handwritten one. The type copy is at, well, it is legible, my lord. 106. In terms of that, my lord, I have produced on 20th. List
No,
it.
this was given by you along with the tender, along with the bid also. Along with, sorry, your application also, this page 126.
Yes.
Huh?
Yes. That was there.
So, they should not have proceeded in the matter.
Yes, they should not have, if that was the case. But they are not saying that.
But having noticed that, how can we ignore that? There cannot be a deemed relaxation.
But my lord, this is, I agree, my lord, this has not been very happily drafted.
Happily adopted means, because if you come to the condition,
Yes,
it's very clear.
yes.
Clause A at page 30.
Yes, my
The
lord,
plan
I
should
am
be-
aware of that.
So, this,
But if it was their case, that it was a conditional list, so I could not have taken that into consideration, then I could have understood that. My lord, no,
Language of
Mohinder Singh
English-
Gill, my lord, by way
language
of,
of English, for you also, for them also, same thing.
but my lord, the reason is, my lord, categorical. Affidavit 3A
3A,
application, yes.
maybe that was the reason why they asked for the 3A.
But they have not said so, my lord.
Because if this is so, we cannot ignore that. This court cannot ignore. That's been it has come to the notice. We'll have to give it a meaning.
But my lord, the fact remains, by way of a communication, they sought the documents, and by the time they sought the documents, this has come
We are
into
not
force,
on
my
that.
lord.
We are not on that. We are on the issue that whether your application is in conformity with page
My lord,
30A.
Page 30A also, my lord, in my humble submission, my lord, when it says applicants having suitable piece of land in the advertised location area, either by of ownership,
No,
long-term lease.
down below, A.
My
The
lord.
other condition with respect to offering of land. are
Yes,
as
yes,
under.
yes,
The land should be available with the applicant.
yes,
Because with that wording,
yes, yes,
that land will not be available with you because this availability has to be on the last date of the application.
yes, yes. That
So
is there.
on
that
that
is
day,
there.
you are not having it.
Yes, that is there, my lord. Not happy
Yes,
after I admit, my
yes.
lord.
What is your prayer? Let's see whether you can save him. Hmm. Till 15. बच गया.
But my lord,
He's
this,
sick.
my lord.
He's sick. On the prayer meet,
15th of-
this matter was listed for delivery of orders today. Full stop. However, the learned counsel for the representing the IOC has expressed his inability to argue the matter further today on account of the fact that the arguing counsel is an outstation counsel and not in a position to appear before this court today. Full stop. Accordingly, this matter shall not be treated as a part of matter again. Accepting the prayer of the learned counsel for the respondent, IOCL lists this matter again after 2 weeks.
Let be after 3 weeks, my lord.
3 weeks. 3 weeks. He expects 3 weeks on a date to be fixed by the registrar. After having taken a view, I did not want to dismiss that. But
Yes.
this is something you will have to answer.
Yes, yes, I will try to, my lord, because
Because
fact
see,
remains
you bring
ultimately.
in any principle,
Yes, I've seen that, my lord.
need has to be there.
I have seen that, my lord. And
This, in your case, when you were arguing the matter, this skipped. The other day, Mr. Tara was arguing a matter. And therein this came to my notice, the same very issue.
yes, yes.
Then I
My lord,
went back.
this came to the notice
Then-
when
then-
the, in the
Then I
motion.
went back,
in the
then I
motion.
examined. I was convinced.
Yes, yes.
Anyway,
Otherwise,
take
fact-
your chance now.
yes, I will take my chances. Otherwise, my lord, ultimately it has to be tested on the grounds they have rejected my.
Fine, but
That is
we'll
also
also have to see whether your application was for.
Yes. But if they have said so, because
They
in
did
that
not.
affidavit, they could have very
They
well
did
said.
not, they did not.
Yes. That is,
Today
that is
also, if
one,
they are-
that is one aspect of
Today
the matter
also,
your
if
lordship
they
may
are
consider.
If they have appreciated what has fallen
Yes,
during this deliberation,
Yes.
maybe they will take up that plea next time. If they have not appreciated, you are in the same.
I understand, but they will come by way of an affidavit, that is not there. Okay,
Okay,
obliged,
item
ma'am.
number kitna hai? Mr. Panning, this is your matter, that,
Yes, yes.
that, Kebang.
Not Kabang, my lord. This is that sports.
No,
quota.
no, no. Oh, yes, sir, this is the
Sports
sport.
quota,
We have allowed your application
my lord.
and, sorry, the Kebang one also has been delivered.
Yes, yes.
Dictated. We have allowed your application to the extent that we hold that out of the 11 candidates who were shortlisted, one had some doubt,
Yes,
so that has to be kept at right. The other 10,
Yes.
against whom there is no material brought on record, the authorities have to take the matter forward.
Yes.
Now, because the records are with the
SIT.
SIT, not with the SIT, with the court now. Because SIT has filed a charge sheet, so
Yes.
materials are before the, all these things are maybe with that, it has gone.
Yes, yes.
So I have directed the authorities to file an application. Get that records, because
Yes.
they can give that original, keep a scan copy.
Right.
After that, I have asked them to finalize, publish the select list,
Right.
and thereafter make appointments.
Right.
Right?
Obliged, ma'am. Thank you.
I got some time, so I dictated.
My lord. Obliged.
ये बना विक्टोरिया, इसमें कोई ऑर्डर पास करने की जरूरत नहीं, हम ये आज डिक्टेट हो गया होगा। ये आज डिस्पोजल Yes. Who is appearing for the government here?
RWD, Your Honor.
Hmm? Jeetara.
Jeetara.
Can you just get hold of him? Ah, Mr. Tarak. I could not dictate the order, but I'll do it today. But I think we'll have to come in. We'll have to accept this. 3 months over. I've tried to go against him a lot, but could not. Hmm? And you also don't have any instruction as to when the charge sheet was filed. Prosecution sanction has been granted. 6/12/2022. But whether the charge has been framed, he says not framed. So I'll record that statement of yours, right? No summons has been given to you, charge, nothing. Can I record that statement on your behalf?
Yes.
Huh?
My lord can record it, my lord.
That no
I-
charge sheet has been filed.
Yes, my lord, and no someone has been issued, my lord.
I'll pass them.
My lord.
इसको भी dispose करो. Madam, ये पीछे दे.
No, 24.
You got your instructions incomplete in all respects.
Yes, my lord.
Then I'll dismiss it. What is here? You have been here, this may be an election related transfer, because you have already completed more than 3 years.
Yes, I have, my lord.
So I think in the law, what is that law? Election law, 4 years, 3, out our last 5 years, you should not be here 3 years, something like that.
That, otherwise I'm
But
on
the
the,
election code has not come into operation.
no, my lord, no, my lord.
Okay.
No. Here, my lord, I have also, my lord, treated, my lord. that,
Disposed of, Mr. Tapin, disposed of. He has filed a representation. 7 days, dispose that. Till that time, don't disturb. Dispose of. Nothing more.
My lord, that's the only prayer, my lord. Deeply obliged.
Write it down, communicate to him. Communicate to him.
Just for you.
I know that. 7 years, 7 days time. I'll pass the order.
No, 25.
I'll give a cutoff date.
May I please, madam? Well, this
What
part,
more, Mr. Sogya will issue a notice at this stage?
my lord. My lord, because my lord,
18, madam.
Yes, my lord. By now, my lord, the arbitration proceedings, my lord, under the AFR
It's
section
also
13.
gone.
It's gone, my lord.
Gone.
So, my lord, since it has been pending since long time, my lord,
But that amendment is with retrospective effect, no? No. 38 has been set aside from its inception or from now? From the date of amendment?
from, my lord, is from 1968 or something like that, my lord.
No, no, just
In
see from
19
when 38 has been interfered with.
Effected with from since 1987, my lord.
This is something
Peculiar,
that
my
will
lord.
create chaos. You are unsettling all settled positions. And when was that amendment brought?
Amendment was brought in the 2023, my lord.
20?
5th April 2023, my lord.
23. See, madam. I know that, but the effect of that is legal fiction is this has got no credence because you have done away with 38 from 87.
Yes. This, my lord, only limited praise there, my lord. By now, the amendment again, my lord, under section, my lord, 3 of the Roman 4, my lord. The deputy commissioner is to, my lord, in case a case is pending before the, my lord, a case is being filed before the, my lord, DC addition deputy commissioner or deputy commissioner, there has to, my lord, remand back to the particular village authority. That is
No, no,
the-
we'll not do that. We'll just issue a notice.
Right.
Heard Mr. Aswakal and counsel for the petitioner. Also heard Madam Kanamli, you are junior government advocate, senior, and additional senior government advocate, appearing for the respond number 1. Full stop. Ms. So-and-so accepts notice on behalf of respondent number 1. No formal notice is to be issued. List of no formal notice is to be issued. However, extra copy of the writ petition be filed by the learned counsel for the petition, but be furnished to the learned additional advocate, the additional senior government advocate by the learned counsel for the petitioner. Full stop. Petition learned counsel for the petitioner to take steps for service of respond number 2 by way of registered post with AD, steps within 3 working days. Full stop. Issue rule, admit notice of motion, return issue notice of motion, returnable 4 weeks.
My lord, in meantime, my lord, may I pray that, my lord, in terms of the order that is
No, no, we are not interfering.
only, my lord, no, my lord, only for maintaining status quo.
We
Is
will
this-
not do anything. 2018 till today, what has happened, you continue to have that happen for another 4 years.
My lord,
Is this the case wherein both the bids have been held to be unsustainable? That's the case? No, no, no. I didn't. Okay, what is your case?
my lord, my case is, my lord, the, as per NIT, my lord, notice inviting bids, my lord, dated 29 January 2024, my lord. My lord, is NIT is start from page 42, my lord. Therein, my lord, clause 7.
I have it.
Clause 7, my lord, it says that clause 7A, my lord, contractor who fulfills the following initial requirements shall only be eligible to apply, my lord. Now here, my lord, the private
How
respondent,
many bidders were found to be eligible in the bidding process?
my lord, since it is the single bids, my lord, that is even the all they were accepted, my lord. All the 4 bid were accepted, my lord.
And technically, who were qualified? Or single,
Ma-
single,
Single,
evaluation?
my lord. They were already admitted. All the they were accepted, bid were accepted, and during the scrutiny, my lord, the letter on, my lord, as per the,
Petitioner.
okay.
You submitted a letter.
Yes, my lord. Now thereafter, my lord, my lord, see the
What is the stage work awarded?
work has not yet been awarded, my lord. So far, my information concerned, my lord. So,
Yes,
focus,
Mr.
my lord.
What is your instruction here?
The detailed inspection has not been received. I received this to why the vendor was giving the waiver of the as per the clause 8, the department has the power. So you will see comparative statement that has been made in is before last page.
But he gave a representation, you had stopped it first, right?
My
And
lord.
they have kept it in
My-
abeyance for some time.
my
and
lord,
then
my lord.
all of a sudden, why that? Why did you keep it in abeyance and what did you find?
Lordship will see that comparative rate.
No, rate is different. He's not with the rates. He is with the justification that the
That's why I'm just-
respondent firm does not fulfill the qualifications. Clause 7. And that I think is your application of.
Yes, yes, my lord. Even it is there's a violation of statutory rules, my lord. District-based interference with Rule 2018 Amendment 8, that has also been
Mr. Tawari,
violated.
you have your instructions in the matter. Have you?
We can do one thing, matter will be listed on 22nd, but we file affidavit with the matter will be disposed of.
Why take the trouble? You bring on record the contention that he has only raised contention with regard to clause 7A. Satisfy this
And-
court that he has it.
And also violation of the statutory rules 2000.
To what extent?
That is, my lord, they are required to file, in order to eligible, my lord, they're required to file the affidavit saying that they don't have the project at hand, 3 works, my lord.
No, 3 words.
Now they stated that he has 3 works, my lord.
Already.
Yes, already. Now that in that view of he's not qualified, my lord. My lord, see at page 134, my lord.
So, given the nature of dispute as arising in the present proceedings, the petitioner is required to furnish to take steps for service of notice upon respondent number 4 by way of dusty mode routed through the registry of this court within 3 days from today. Full stop. On taking such on service of such notice, the petitioner shall file an affidavit in the matter. Full stop. Mr. G. Tarak, learned counsel appearing for the UD and Housing Department. Oh, sorry, P. Tapo, learned counsel, standing counsel, UD and Housing Department shall, on the next date fixed, place on record the original records pertaining to the scrutiny as made by the committee of the bids received of the bidders in pursuance to the MIT dated 29/1/2024. Full stop. The respondent authorities shall clearly, in the records so produced, indicate the manner in which the indicate the qualifications of the respondent number 4. Both qualifications of the respondent number 4, both in terms of clause 7 of the MIT dated 29/1/2024, as well as the allegation that he has more than 3 projects in his hand under execution on the date the notice inviting bid dated 29/1/2024 was so issued. Till the next date fixed, the respondents may process with the process the matter. However, the work order shall not be awarded without leave of the court. List this matter again on 23/2024.
Deeply
Also, the above directions, interim directions, shall be further considered on the next day on receipt of the records, on perusal of the records to be produced by Mr. P. Tapo, learned counsel, learned standing counsel, Urban Development Department, as well as appearance of the respondent number 4.
Deeply obliged.
Matter number 27.
List for motion creation.
May it please, Your Lordship.
Nurse recruitment.
Yes, my lord.
What is the stage?
No re-advertisement as of yet, my lord.
Advertisement not yet issued.
Yes, only ground number 1 is to 3, my lord.
1 is to 3. Yes.
Yes, I already
Mr. Counsel,
directed.
How long will you take?
For respondent number 4.
Who is the concerned respondent here, Mr.
Mr. Tagum.
Mr. Kapin?
Mr. Tagum. He was just here doing motion.
Mr. Tafo?
Tagum.
Tabun?
Copy नहीं दिया गया.
Tabun is here.
Yes.
Sabah Tabun. Huh. Mr. Tabun, have your instructions. Have your instructions.
I'll get instruction.
Because the advertisements have not been issued. Ensure that the advertisements is not issued till the instructions are not placed before the school. Huh? Today, today may not be possible. Have it on Thursday.
But the Thursday I have some difficulty actually.
Then Monday.
Tomorrow, my lord. Otherwise, my lord, 1:3 is on the basis of an office memorandum. That is not even authenticated in the name of the governor.
I know that.
And there is a judgment of this honorable court, my lord, wherein said these are at best can be termed an irregularity. Yes. And that was a case where the less number of persons were caught. Here, my lord, all the persons who have
Whoever they were
Yes.
there.
Yes.
So have your instructions. If there is something more than what he has said, he may have suppressed something.
Oh, my lord, it is in their order itself, my lord. It is in their order.
So we just want a confirmation, but don't issue fresh advertisement. We don't want hurt party rights. You inform the respondents. I'll not record, but you inform. On the prayer of Mr. T. Tabu, Standing Council Health and Family Welfare Department, list this matter again on 19/2/2024, on which date he shall place instructions, he shall receive instructions as to why the selection process was required to be abandoned and a fresh selection process directed to be held in the matter.
In respect of others, my lord, they have allowed.
This is by a committee or this is by the department itself, not by the APPSC.
No, man.
Because APPSC has a rule, 1:3.
Yes.
You don't have a rule to that effect.
We follow the office memorandum guidelines.
I have annexed it, man. I have annexed it. Page 99.
Page?
99. It is not even in the name of the governor, man.
This is even APCS applying the same rule, page 99.
They do, my lord, but I have a judgment of this honorable court.
Show me.
2019, volume 4, 223.
On this office memorandum.
No, not this office memorandum regarding the ratio, madam. 1:3 ratio. Non-conformity.
Do you have a service rule with regard to selection for nurses here?
I believe they have.
Have a service rule?
Madam, there is a matter, the recruitment rules there, madam. It is,
There is, my lord. My learned friend, in fact, sent it to me. It was not at all legible, so I could not annex it. In fact, my learned friend sent it to me. They will have to get it from the department.
Yeah, that would clear the issue.
Yes, the recruitment rules, paragraph 29. Madam. Here, my lord, in fact, less number of candidates than the ratio provided was called for. Less, madam, not even more. Paragraph 29.
Okay.
Yes.
Okay, got it.
Yes.
Okay. On the prayer of Mr. Likhana, so and so list this matter again on 23/2024, on which date he shall place before this court. Likha their term instruction, along with a copy of the recruitment rule for the governing the posts in question in the present proceedings, right?
20.
May I, Your Lordship?
LAC cancel,
Yes, Your Lordship. LPC,
LPC. Heard, madam, your name?
R. Taku, Your Lordship.
Huh?
R. Taku.
R. Tapin, learned MS R. Tapin, learned counsel for the petitioner, and also heard. Madam, you are appearing for both. Learned counsel, appearing for respondents 1 and 2. Appearing, you're the junior government. Junior government. Issue notice, returnable 4 weeks. Miss so-and-so appears and accepts notice on behalf of the respondent number 1 and 2. No formal notice is to be issued. However, the learned counsel for the petitioner shall furnish to the learned junior government advocate adequate number of extra copies of the petition within 2 working days from today. So, on the next day, the learned junior government advocate, Madam का नाम लिखेगा, shall place before the court instructions, shall receive instruction with regard to the allegations as raised by the petitioner in the petition.
Lordship, if I may, in this, I'm praying if the interim status quo may be.
I would have given you, but this is a matter of July.
Your
And
Lordship,
Madam, one thing you have not mentioned in the petition anyway, that you got to know about it only, say, a month back, or a day back, or a week back.
that has
You
not been
knew
mentioned.
it from then.
But Lordship, my prayer here is that, Your Lordship, though this has not been filed since it is of 2023, but then if Your Lordship will see, there has been series of complaint that has been filed before the DLRs
I
as well
got
as the
it, ma'am.
Deputy
I
Commissioner.
got it. But this is an order which you, further, it is provided that issue notice on interim prayer, returnable on the same day. So,
In
list
that
this
case,
matter again on when? Short day? No.
Lordship, date, a fixed date may be given, yes,
Short day,
Lordship.
madam, short day. 26th March, 26/3/2020. हाँ? ऊपर में 4 weeks लिखा है क्या? Return अब नहीं लिखा ना? Issue notice नीचे में लिखेगा 26th. I would have given you answer. There is no statement to that.
But if Your
You should be
Lordship will
very
see
careful
that,
when you make.
because on that, on the basis of
Complaints
that
is
affidavit.
your complaints with regard to that person you made.
Yes,
that
Your
somebody
Lordship.
is trying to improve. But you have not ever that this order, although placed behind your back,
Yes.
you were not in knowledge of that. You just came to
Lordship,
be
that
in
I
knowledge
have
of that.
mentioned that in my paragraph,
Where?
that was not.
I may have missed it.
Yes, Your Lordship.
Where? And that you have just come to know about it. Where is it?
If Your Lordship will see, I have mentioned.
Just show me that statement.
Yes, Your Lordship, we'll come to that. If Your Lordship will see in page number 8, para 7, Your Lordship.
Page number 8, para 7.
Para
Yes.
7. The petitioner, since he heard nothing nor received a reply notice from either the office of the Deputy Commissioner and the District Land Records and Settlement Office, she and her husband, when inquired about the false application filed on behalf of the petitioner to cancel her LPC and applied for the certified to her utmost, then she came to know that this was there, Your Lordship.
But when, madam?
The date has not been.
That is the issue. The next time, make
Yes, Your Lordship.
a perfect statement.
I agree with that, but if Your Lordship,
Because
why,
the writ court has to interfere.
that is there, Your
It
Lordship.
has to know that this is the reason why I'm interfering.
That is there, Your Lordship. But if Your Lordship
And
once
that's
will
the only
see,
thing I searched for you in your.
I agree with that, Your Lordship, but if only
Next
if Your
time.
Lordship will see,
Next time, 26th, try.
because the construction has been started by the.
We can't help it.
That
It's
is
your
there.
fault. 26th.
Not always.
Please, Your Lordship,
Yes.
Lordship, this matter pertains to regularization of service of the
Hmm.
petitioner, Lordship.
How?
Lordship, petitioner was engaged as casual worker in
Show
the
me the scheme
scheme,
for
Lordship.
regularization.
Some, by
Cannot be. You are
Complying the-
claiming regularization. Show me under what law I'll regularize your service.
ratio laid down in the Uma Devi case,
Uma Devi case. Okay, when did you complete 10 years?
Lordship.
When did you complete 10 years?
Lordship, I have engaged in the year 2022, Lordship.
22.
Yes, Lordship. And since then I have been in
22.
service. 2002, Lordship.
2.
Yes, Lordship.
So 10 years, 22. Uma Devi is of 2006. Para 53 says 10 years on that day. Then
The, even though the
where is the scheme?
department
Show
has,
me your initial appointment.
In
Where,
it-
where is it in
But
pursuance to a
there is-
selection process?
there is a certificate issued by the,
No. Show me the selection involved. Irregular.
irregular. Lordship.
You were picked up from the road.
But she has
You were
been in,
picked up from the road.
but she has been in service for
Fine,
20
very
years,
good.
Lordship.
If you are not there, there would have been somebody else.
Recently, her service.
Show me your right to be regularized. I'll immediately come.
Department has initiated some process to regularize the service of the
Then you
petitioner,
wait
and
for
the
the process to come. to an
respondent
end.
number 4 wrote a letter to the respondent number 3 for.
You were terminated.
Yes,
Thereafter, you
after
were
revoked.
brought back.
Yes, Lordship.
Then, where is your initial order of engagement?
Engagement, Lordship, in this case, Lordship, there is a certificate issued by the respondent number 4 at page 14, Lordship, and which goes to show that she has been in service since
Yes, madam.
1/6/2022, Lordship.
Nothing. Just through an application, ask for regularization. You should develop it.
Yes, Lordship, there should have been something brought to the notice. On this
You
matter.
can't just come to the court, file an application and let the court do the work for you. You will have to bring on record the materials. Uma Devi, not applicable. Then the state, everyone who is working will have to do
Will
it.
be a-
They have an act, you're not even a contingency. Is casual labors also covered under that act? That 20 years thing? No. Contingency.
But at this stage, Lordship, noting.
On the next date fixed. Madam, I don't want to dismiss it. I'm just putting it in your mouth. Ms. So-and-so praised and is granted 2 weeks' time to receive instructions in the matter. List this matter after 2 weeks.
In the meantime, by filing a affidavit, I'll bring some appointment. And
Madam, you get something. I don't want to dismiss it. That's it. Anything you can. It's up to you.
How long you Lordship?
Wait. Here, my lord, both the bids. Here, my lord,
Cancel.
yes. Now, my lord, my case is all along, my lord, just to accommodate the respondent number 6, who was not even qualified to bid, my lord.
You have yourself admitted that your rate is around 15% below.
No, no, my lord. No,
No, 9. No, this is the one.
yes.
There are 18.
My bid is
9
9 crores
86.
86.
And his is
1,720.
9 crores 87.
Yes. So I have said.
What was the reserve price?
The 10 crore 47 million. Because they have not said that my bid was not responsive.
Where is that order by which it was decided?
Page 120. Why not just like that?
Have they issued a notice, fresh notice also?
Yes, yes, ma'am.
Have you participated here?
No, madam.
Why? When is the last date?
Last date is on 18.
18th of this month.
Yes.
You apply. Will state,
Yes,
what do you apply?
Yes, ma'am.
Mr. Peter Lalim, Standing Council, UD, and Housing Department, Government of Arunachal Pradesh, shall on the next day bring on receive instructions as to why the decision, why, how, as to in what manner the conclusion was arrived that the rates quoted in the petitioner firm
Yes.
as well as the
Respondent number 6.
respondent number
6, ma'am.
the 6 firm in pursuance to the MIT dated
13/1/2024.
13/1/2020 was
24.
reached, was decided to be abnormal in nature. Full stop. It is seen that the respondents have, on cancellation of the earlier tender process, issued a fresh bid,
This was on 4th, madam.
issued a fresh bid on 4/3/2023, and the last date for submission of bids as stated in the bar is slated on 18/3/2024. Full stop. The petitioner is hereby directed to, is granted leave
Yes.
to submit his bid in pursuance to the NIT dated 4/3/2024. However, after update respondents on receipt of bids in pursuance to the notice NIT dated 4/3/2024 shall process the same. However, the financial bids of the bidders in pursuance to the NIT dated 4/3/2024 shall not be opened without leave of this court. List this matter again on 26/3/2024.
Man, okay.
Because I've just stopped the financial bids
Yes.
so that
Yes.
your rates are known now, so
Yes.
we don't want to prejudice you.
Yes.
You proceed,
Yes.
open, but don't open the financial bids.
Obliged.
Till the next returnable date, Buliga.
Obliged.
May I please?
Yes.
Lordship, here the petitioners are the project affected landowners.
You couldn't file a contempt.
Yes,
because the time had already passed before you could take a call.
Yes, Lordship.
So if that be the situation, we will issue a notice
Lordship.
at best.
Lordship.
Because the decision is already there.
Yes, Lordship.
Yes, Mr. Khan.
Okay, in fact, the very decision, basing on the division bench, order, that division bench judgment has been taken before that.
Supreme Court, pending. Okay. We'll not say anything. We'll just issue a notice. But Mr. So-and-so, learned counsel for the petitioners. Also heard Mr. N. Ratan, learned additional advocate general, Government of Arunachal Pradesh. Proceed. Issue notice, returnable 6 weeks. Proceed. Mr. Ratan, who will take notice on your behalf? Okay, fine, I'll do that. R. Dasat, Ms. R. Dasat, appearing, assisting Mr. N. Ratan, receives notice on behalf of respondent number 1, 2, 1 and 4. 1 and 4. Mr. R. Soikia enters appearance for respondent number 2. 3 for respondent number 3. Who is for 2?
There is a pending portion.
What is it? Huh?
D. Kamduk. Coffee already served.
D. Kandu.
D. Kamduk.
Learned Standing Council Land Management receives notice on behalf of respondent number 2. 6 of respondent number 5 steps upon respondent number 5 and 6 be
5
taken
and 6.
by the petitioner through Mr. M. Kato, Deputy SGI.
Coffee already served.
No formal notice be issued. However, the learned counsel for the petitioner to submit to the respondent, the counsel appearing for the respondents, requisite extra copies of the petition.
Deeply organized.
My lord, yesterday my lord has asked me to, who is the appointing authority? My lord, I have brought the promotion order of the petitioner, my lord, at serial number 4. This was by the Principal Secretary, Finance, my lord, at page 3. So, my lord, in any case, my lord, yesterday we have skipped one paragraph of our affidavit in opposition, my lord.
Please show.
This is at paragraph 12, my lord. If my lord sees our affidavit, paragraph 12. The answering deponent begs to state that the answering deponent begs to state that the said intimation letter addressed to the Chief Secretary, Government of Arunachal Pradesh, has not been received in the Director of Accounts and Treasury till date. It is also confirmed from the Chief Secretary's cell that such intimation letter has not been received in the cell till now. My lord, therefore, my lord, if my lord will see in the loose sheet, we have given our minutes of the review committee.
The second one.
Yes, first and second in both. This was, the chairman was by the Chief Secretary. In the minutes itself.
First one is 1210.
1210, my lord. In the second, third paragraph, my lord, it was also informed that no formal intimation has been received from the suspended officer or from any authority about his release from detention till that. This was also attended by the chief secretary also as a chairman, my lord. Only in the second review, my lord, on 23/11.
From the CBI you get. that.
Yes,
7.
CBI, that intimation has been given by the CBI from 7/11/23.
So accordingly, you immediately called the review meeting on 23.
Yes, my lord, and that was extended from 24/11 to 21/2/2024, my lord.
And thereafter,
Thereafter, my lord, the latest order, my lord, this suspension has been till 21/5, my lord.
what is the stage of the inquiry, the departmental proceedings?
My lord, departmental proceeding is going on, my lord. Yes, yes. He has
Inquiry
been
officer
summoned.
has been appointed.
Yes, yes. He has
Inquiry
been,
is on.
inquiry is going on.
We'll do one thing, Mr. Consul. We'll ask them to complete your inquiry in 6 weeks, 6 months. Oh, 3 months, 4 months, whatever it is.
Lordship,
Till that time.
Lordship, may I make some submission?
Yeah, yeah,
Lordship,
please.
Lordship, here since.
Why should you ask? You are right, it's your right.
Lordship, yesterday I was submitting that there has been violation of some technicalities that had the procedure that has to be followed that has not been followed in my case, Lordship. That was my
Now,
whole
establish
contention.
then, if that be so, establish that your release was known to them.
Lordship, that part, Lordship, may I convince Lordship? Lordship, presuming but not accepting, Lordship, that regarding the intimation letter that we have submitted before the Chief Secretary. Lordship, may kindly, I've prepared one list of dates again for your convenience, Lordship. For Lordship's convenience. Lordship, may kindly come to serial number 7, Lordship. I have filed, Lordship, accepting but not this thing, Lordship, regarding the intimation letter. This very writ petition, making the parties, Lordship. In the writ petitions, Lordship, I have made party to the Principal Secretary as well as the Director, Lordship, as respondent number 2 and 3, Lordship. Now that writ petition was filed on 12/6/2023, Lordship will find it in my affidavit, Lordship. And this very application was moved on 26/6/2023, Lordship. On that very day, notice was issued.
Got it.
They
Mr.
came to know,
Ratta.
Lordship.
Mr. Ratta. Yes. He has.
They cannot skip that, Lordship.
Just, yeah, he's made a very interesting point. See, your first review is of 12/10, right?
Yes, madam.
On that day, you have already filed an affidavit before this court.
12/10.
You have filed an affidavit on 27/9.
Yes.
And in that affidavit, this factor was known to you.
Yes, Lordship.
Who has filed the affidavit? Interesting, very good, intelligent point. 1, 2, and 3.
1, 2, and 3.
Who is 1, 2, and 3?
Principal Secretary, Director, Lordship, including Chief Secretary.
My lord,
How
that
can
is
you-
it. Yes, my lord. By the time, in his petition, he has stated.
Forget it. That he is already released. Forget the letters. I'm not worried about the letters. But that he is already released is known to you.
That is in his petition, he has stated.
He has brought the
But,
bail order also.
and then.
No. Mr. Ratan, he has brought the bail order also. The bail order is also there.
Lordship, it is there.
The bail order is there.
Page 50, Lordship.
And you will reply to that paragraph of the bail order also. Where is the corresponding paragraph to the bail order? Hmm? I must say, I did not think on that lines. I'm really happy to get this argument. That is the beauty you have that side. You can always develop, and you should. Where is that corresponding paragraph? Annexure, bail order is annexure.
Annexure 7.
7.
No, no.
So let us see the statement 6. 6.
Paragraph 12, Lordship. Paragraph 12 of their affidavit in opposition.
No, no, no. In your petition that you were granted bail.
Paragraph 10, Lordship.
Where is your bail order?
Page 50, Lordship.
50.
Lordship.
50.
Well, in paragraph 10, he has only stated that regarding the representation submitted to the chief secretary. In the annexure, the order dated 9/3, the bail order has been annexed without making any statement.
Lordship, first line, that is to state that the pursuant to the release of the petitioner from detention on 9/3/2023, Lordship, I have mentioned.
9/3. And where is the reply to para 10?
Para 10 in my
page
paragraph 12, page 5. He has stated only with regard to the representation submitted before the.
No, he has said he is already released
Pursuant-
on detention on 9/3.
Yes,
Para
Malad.
10.
That pursuant to the release.
Pursuant to the release
Of
on
the petition,
9/3.
on 9/3, the petitioner has submitted.
That knowledge is with you now.
No, Malad,
And you have
that's-
replied to that.
Yes, my lord.
You have not denied that.
Yes, he says that the petitioner has submitted the representative. Pursuant to.
Fine. He says that word detention or release of the petitioner from detention on 9/3.
Yes, my lord.
So
Exact.
that knowledge can be imputed to you on 27/9 when you file this affidavit.
Exactly. That's why in our reply, we are saying that such representation was never there. Never found in the chief secretary's cell also.
Okay, Mr. Counsel. The letter has not reached them. You have not also counted that. The only material now is this statement of yours. Okay? Which you say the notice was issued on
26/6/20.
26/6/20. That is the date of the knowledge. So
Lordship.
90 days from that.
Lordship, so why, Lordship? I'm coming to that also, Lordship.
90 days from that would be.
Last date would be 90 days will be serial number 12, Lordship, of my list of dates, Lordship.
26/9.
26/9/2023. Now review is on 12/10/2023, Lordship. 90 days
Touch and go.
expires.
Touch and go.
Now, my lord, therefore,
Touch and go.
when would if he counts it from the day of issue of notice, that also.
Service of steps.
Yes, my lord.
No, let's go into that. Let's go into that. Once the technicality has been taken, I think we should go in. Let me see.
It has to be intimated, my lord. The rules provides that if the petitioner has to intimate about his release directly to the.
Steps here. नोटिंग में नहीं था, ये तो अपन सबने पूरा लिया था ना, इन्होंने लिया।
Extra copies, my lord.
गवर्नमेंट को जो देखो एक्स्ट्रा कॉपी जो देता है उसके बाद एक्नॉलेजमेंट यहाँ पे ये वाला ये एडिशन। Where do you keep, Mr. Ratan, where
My
is
lord, in our extra copies were received on 12/7.
12/7? 3 months would be 12/10.
12/10.
Mr. Counsel,
Extra
That's why I said,
copies.
your argument really out of the box, appreciable. But unfortunately, may not help you because you took steps on 12/10. So he will
12/7.
forward this after that. And they will come to know immediately on that.
Lordship, may I peruse the
Further, my lord, one more submission, my lord. My lord, the rules provides that it has to be intimated by the petitioner.
In a case, let's say, this is
Yes,
also
madam.
intimation. It
Yes.
does not say that it should be in writing in such format, in some
Yes,
form
madam.
A, form B. This is also intimation, right? You have any document to show
Lordship,
taking
no.
of steps?
Taking steps, no, Lordship. I have to see that.
There has to be a talabana here.
This is before filing.
वो फाइलिंग का आगे का फाइलिंग का पीछे
Extra copies, we enter it.
you enter.
Yes, my lord. Extra copies received. 3 numbers on 12/7.
Okay, let me examine.
And my lord, one more thing, my lord, Chaudhary's case itself, my lord, defining the time limit for completion, my lord, that has also been discussed there. Whether it will be proper for the court.
See,
In view of the
don't go
subsequent.
into Ajay Chaudhary in this case because if you go into Ajay Chaudhary, CCA rule literally will have to, because it's amended now.
Yes, ma'am.
Ajay Chaudhary, the requirement is 90 days if you don't issue a, I don't know how the interpretations, what I understand. 90 days if you don't issue a show cause,
Yes, ma'am.
right?
Yes.
If you issue a show cause, on that same very day, you must have a review. Whether you want to extend it or not. Then this 90 days thing will not. But the requirement is on the day you issue it, that second line,
Yes.
para 21 second line if you read,
Yes.
you will have to have a review. So if I apply that here, you don't have a review on the date you have issued the
Yes,
show
yes,
cause. So we'll not go into that because in view of the rules that are holding the bill. Madam, HUD deal on a council for the parties at length list this matter again on 15/2/2024 for delivery of orders. It's got delivery of orders. Let me see.
All right.
All right.
Tentatively, 3 months, we will ask them to conclude the proceeding. You cooperate. 3 months.
Lordship, I'll just try to figure it out when the extra copies were served. Just then. Much.
And also, remember the amendment to the provisions of that proviso to the CCS Rule 10(7). Proviso. That says this 2 years is the maximum if there is no show cause issued. Now, if a show cause is issued, that part is not there.
Not there.
And Ajay Chaudhary also does not, after issuance of a show cause and a review, does not say anything. Keep that in mind.
Lordship.
My lord, the present incumbent executive engineer is trying to harass me for no reason. In fact, lordship, they have.
That non-payment of bills.
Yes, lordship. In fact,
But Mr. Counsel,
yes, lordship.
they have filed an affidavit in the matter.
Yes, lordship. I have even filed the rejoinder
That's
also.
fine.
Yes.
Rejoinder, maybe, but they have set a very categorical terms in paragraph 4.
That I have answered, lordship.
Page 3 and 4. What is your answer?
My answer is at page para 9, lordship.
Of your reply?
Yes. I have clarified everything, Lordship. My lord, basically, the affidavit in opposition says that I have not supplied
Mr.
whole.
L. Pramit, learned counsel for the. You are standing counsel for? In this case?
Power department.
Power
Maybe allow to
department.
place on record this.
No, 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 wait, just wait. Only para 9, Mr. Para 9 or a clarification in some other paragraph with regard to that contentions?
Para 9, Lordship. Para 9,
Only para 9.
yes, Lordship. They have only said that I have not supplied this, fulfill all
That's
these
it,
4
that's it,
items,
that's
Lordship.
it,
But
that's
I
it.
have clarified it.
Para 9,
Of my
no other
rejoinder.
paragraph is required.
No other paragraph is required.
Para 9, 10 and 12.
9, 10, and
Mr. L. Pramit, learned standing counsel, power department shall receive instructions with regard to the contentions as made by the petitioner in his rejoinder affidavit in para 9, 10, and 12. Also, such contention was made in response to the contentions as made by the superintending engineer, Department of Power, in his affidavit, more particularly those made in paragraph 4 of the said affidavit. List this matter again on.
My lord, before this, my lord, here I have to, they are saying some things of time, my lord. Yes, my lord, this involves so many new documents, my lord. They are saying we need to verify the report, my
I'm not
lord.
concerned with that. You just get these instructions. List this matter again on 3/4/2024. You get these instructions. Your contention is we can't pay him that 1 crore odd because he has not supplied.
Right.
He has brought on record clarifications. The problem for this court is if there is a dispute, we cannot enter. And this court, Supreme Court is very clear. Non-payment of bills, we can do if there is an admission to be admitted part. But now he has brought on record clarifications. You clarify that.
See, that time, my lord,
Will not go by this. You will have to. You can't let a citizen hang like this. If he is in fault, point it out, we will dismiss his petition. But just for the sake of denying to him the payment, you can't continue to deprive him. This is a contract of
2018.
1890.
truly, my lord,
This court will not.
my lord, appreciate, my lord, day or 2 days, we will have model. code of
Okay, I'll
conduct,
give
my
you
lord.
one more day. I said, कितना तारीख बोला मैडम? 4 बोला, 8 कर दीजिए. 3 बोला, 8 कर दीजिए. 8
Lordship,
for primary.
yes, Lordship. Lordship says this is the financial year month, end of the financial month of the
I know
year.
that,
Lordship,
but can't help it.
Lordship may kindly observe the pendency of this repetition.
Oh, it is also to be noted that the respondent authorities in the event is satisfied that the petitioner has on perusal of the clarifications as provided in the above noted paragraph by the petitioner, the respondent authorities are satisfied that the petitioner has discharged the contract in the manner required and the supplies have been so effective has been completely effective. Dependency of this petition shall not be a bar to release the amounts which are found due to the petition.
Much obliged.
Yes, who is for respondent number 15?
Lordship.
You file an application, withdraw your affidavit.
Yes,
Now you are not filing your fresh affidavit. Why?
Lordship, I'm unable to contact the respondent number.
Then we will say,
So I
you
may
are
be,
right, we are closing.
Lordship, I may be
No,
given.
no, this court very reluctantly allowed you to withdraw your affidavit.
Lordship, the issue was, I have the order with me, Lordship, the order dated,
And Mr. Counsel, we know. We know that your order is 24/1,
yes, Lordship.
right? And the time limit is 2 weeks.
Lordship,
And we are today in March.
Lordship,
Why?
Lordship, the affidavit is prepared, affidavit in opposition is ready, but the issue is I am unable to contact a respondent number.
He is not interested.
No, Lordship, that I may be given a week time so that, or
Okay,
fixed
fine.
that.
Oh, my lord, the respondent number 515 is trying to delaying practice of the
Will not
wastage of the
allow
times of the
Lordship.
court. My lord, it's my single phrase that, your lordship,
let me drop from this writ petition, drop that respondent number.
You
15.
invited them.
Yes, my lord. So that because of the now.
You
that-
invited
Yes,
them,
my
now
lord.
they are
My lord.
creating trouble. We can't
My lord.
because we
My
have
lord.
already, we
My-
give them a week's
Yeah.
time.
Yes.
You file an application for deletion of the names.
Yes, my lord.
You file an application. File an application and be careful.
Yeah.
Whether on deletion, whether your right that you are claiming here will subsist.
My lord, but the respondent number 15 has requested me this morning also. He filing tomorrow. If there's a respondent number 15, this council request me to filing tomorrow.
Tomorrow.
Tomorrow. He assured me that filing tomorrow. Let the matter may be listed on the 15th for the admission hearing. My
Lord,
Did you make any prayer? Did
Yeah,
you make any
yes,
assurance
Lordship.
like that?
No, Lordship, I've said that I'm unable to contact respondent number 15. So in fact, I have requested him for adjournment, Lordship. So the,
On
fix
the
the
prayer
Lordship.
made by the learned council for the respondent number 15, Mr. T. Vishnu, right?
Yes, Lordship.
Tita?
Etatak.
Etata. However, above praying for granting to him further 1 week time to file the fresh affidavit on behalf of the respondent number 15 in terms of the order dated 24/1/2024 passed by this court in ISC number 169 AP 2023, which is vehemently objected to by the learned counsel for the petitioner. This court reluctantly grants to the petition to the respondent number 5 7 days further time to file to bring on record his affidavit. Also, the affidavit be filed invariably.
Today's 12th, Lordship. 12th.
Invariably before 19/3/2024. List this matter again on 22/3/2024. In the event the affidavit as directed above is not filed before 19/3/2024, no further opportunity would be afforded to the respondent number 15 to bring his stand on record by way of filing an affidavit.
Deeply obliged.
I think that takes care of your apprehension.
Yes, ma'am. Fabulous.
Item number 7.
Yeah, my lord.
Yes, madam, what is this?
Yeah, madam, we have,
My lord,
we
what
want
is-
this NOC, madam. NOC, but,
fine, I got it.
but,
He is occupying some government
yes,
land,
ma'am, encroaching. Yes,
encroaching on.
Yes.
That's a misconduct.
yes, ma'am.
Drop proceedings against him. Why?
That's
Do
true,
you
madam, but
deny-
there's one notification, madam.
I
I
know that.
annexed it in my.
How can that notification stand, whether the service rules require this?
No.
If this is a misconduct, drop proceedings. Once you drop a proceeding, issue a show cause to him. No promotion is entered. He's not entitled to it. But without doing that, only on the ground of vigilance clearance, you cannot keep him.
Only
Okay.
because of this notification, madam, we have.
Huh?
Only of this notification, madam, we have not issued that.
Where is that notification? Show me.
Notification starts
That
from
MSCP promotion, that
No, madam.
notification.
yes, madam.
Annex 3, madam, in our.
Page
affidavit.
62, my lord. From page 62 of the writ petition, my lord.
In our affidavit also, madam.
This notification order, my lord, has not been issued by the governor, my lord. There are 4 notifications, 4 orders, my lord. That has no relevance to my recruitment rule.
No, this will not This cannot, madam, consideration for promotion is a fundamental right. No dispute, there can be no dispute on that. Now, if you have to deny a person his fundamental right, there has to be material. And the material, only material you can do is if he has committed a misconduct. This is a misconduct, no issue on that. Drop a proceeding against him. What do you say on that? Otherwise, how can you prevent a promotion from taking place?
For 36 years, my lord. I have not been promoted.
Not accepted.
Even in my lord, para 16, I have stated, my lord, there is no criminal case or departmental proceeding pending against the petitioner.
Show me the, this is the one. Okay, madam, got it. Let's say this is mandatory. A vigilance clearance is mandatory. Who should take that vigilance clearance? He or you? Why should he take?
He has to apply.
Your document says that it's you who have to take.
Yes,
What
ma'am.
steps have you taken? Come to page 64.
Yes, ma'am, 64, my lord. Yes.
Vigilance following procedure shall be adopted with immediate effect. Vigilance report request clearly stating the purpose for which it is required shall be sent by an officer not below the rank of joint director under secretary of the department where the official officer is currently posted to the under secretary vigilance. Madam, it's you who have to take. What steps have you taken? Your affidavit does not say so.
No, madam, in our affidavit, we only said that this notification, we are relying on this notification,
Okay,
madam.
his promotion is under consideration. What steps have you taken to consider?
We are waiting for.
Perfect. Get that. On the next day fix, Madam ka naam likhiye. Shall receive instruction as to the steps taken by the departmental officials for obtaining the purported vigilance clearance in respect of the petitioner. Also, it is stated, it is to be noted that in the event satisfactory material is not provided for, further orders as may be called for in the petition shall be passed by this court. Just get that done. If there is something, we will be.
I don't think, madam, there will be
Then
something.
if you don't think, we are with it.
Obliged.
Yes, Mr. Ratan, what is this? If you require a vigilance clearance, I've been seeing this. Why should the employer run around for this?
Yes,
It's
madam.
you,
Yes, madam.
it's
In
your
fact-
headache. What headache does he have?
In fact, there are many instances
This should be
that
stopped.
because of the non-providing of the vigilance clearance.
Vigilance clearance, even if you read KB Ranagi Raman, said even a pendency of a vigilance inquiry cannot be, you cannot resort to seal cover procedure.
Yes.
So, if there is a misconduct committed against him, drop proceedings.
In fact, procedure should have been that it should be a internal communication between-
Yes.
without
That's-
even letting the
Anybody know.
no.
It's your satisfaction, you get it.
Yes.
But now I find that that is being used to prevent people from being doing.
In fact, the officers are made to run for their vigilance clearance. That is the
NOC.
yes.
And see, Mr. Ratan, try to take it up with your authorities.
Yes, madam.
If a person like him, he is occupying a government land, right, without authority, building, he is committing a misconduct.
Yes, madam.
Drop proceedings against him.
Vigilance may
That
give its
will
report.
immediately stop his promotions.
Yes.
But in the circuitous manner, you should not do it.
Vigilance may give a report to that effect.
And then you can, that will also not prevent him.
Yes.
Because say consideration for promotion is a fundamental right.
Yes, madam.
So you will have to deal with it in that. Promotion is not a fundamental right. But consideration to promotion is a fundamental right.
Yes, madam. That's why the
Madam will give it. Next day you also address this court.
Yes.
On Thursday. Madam, brief him also.
the report, report if any adverse against that person.
Draw proceedings.
That proceedings may be drawn or even that can be considered during the DPC. DPC will decide. Yes.
This is done. Thursday.
Yes, my lord. May I please?
You were supposed to place some judgments.
Yes, my lord. Before placing the judgment, my lord, on the last occasion, my lord has posed the question. regarding the provision of Order 5, Rule 95, subclause 5 proviso. In that proviso, basically the proviso was that a declaration may be made within 30 days if the summon was not received back. That was the proviso. My lord, then in that case, it is considered as a deemed service. But in our case, had the court has declared as a deemed service? No. Why? Because if they had declared, if the court had declared as a deemed service, then there was no necessity of issuing for substitution of substituted service. And in substituted service, in other way, there is no statutory provision for issuing a substituted service. There is a need of 30 days time duration, my lord. That is my humble submission, my lord, in that regard. And one more, one judgment.
Take me to that provision once.
Order 5, Rule 9, 5, subclause 5.
Now come to this provision for substituted service 20.
Yes. Substituted service. What are the preconditions for substituted service? Where the court is satisfied that there is reason to believe that the defendant is keeping out of the way for the purpose of avoiding service, or that for any other reason the summons cannot be served in ordinary course. Means the court has to satisfy it. But there is no provision that within 30 days, if the court didn't.
I got it.
My lord. And in that case, one more, I would like to place one judgment of Honorable Delhi High Court. Para 15. A perusal of Order 5, Rule 95 CPC would reveal that the court is empowered to give a declaration of service if till 30 days the acknowledgement due is not returned back. However, this rule does not provide for fixing the date on which the opposite party would be deemed to be served. Section 25B4, subclause 4 notes that if at the address at which the tenant or his agent actually or voluntarily resides or carries on business, notice is sent by registered post AD on an acknowledgement for refusal to take. My lord. And
anything more?
I'm coming, yes. The appellant, Honorable learned senior counsel, has relied upon the decision of Nirja Realtors, my lord. Lord will take up the Nirja Realtors one. This authored by Honorable Chief Justice of India. This is not applicable in our case. Why it's not applicable? First, my lord, may come to para 8, my lord. Basically, the suit was decreed ex parte. Thereafter, they filed a first appeal under section 96, my lord. When under section 96 applies, my lord, it's against the original decree, not against the provision of under Order 9, Rule 13. Because under if you want to file an appeal that is against the order, that is under order 9 rule 13, then you have to come under order 43 rule 1B, which they have come up. But if the limitation in this case, order 9 rule 13, as it is very clear that Lordship may one more, sorry, one more take up the proviso of order 9 rule 13. Basically, the second proviso, order 9 rule 13, the second proviso, which was amended in the year 1976, originally it was not there in the CPC, provided further that no court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in service of summons. That has been cleared by Honorable Supreme Court in Sunil Potdar case 2008. I have already relied upon that. Basically, irregularity in service
Will not be.
And in the real, in the Nirja case, that will not be applicable because the court has not dealt with that issue because that was the
Not called them.
yes. That is my humble submission. my
It
lord.
shows that once an appeal is filed,
Yes.
then then resort to order 9 rule 13 will not be applicable. That's basically the underlying factor here.
Yes. Basically, they had two options, my lord. First, from original decree, they can file under order 41 rule 1-2. That is they can take grounds on all issues, on merits also. But in under order 43 rule 1, they cannot because it is under order 9 rule 13. Only on the basis of summons they can.
Done. Anything more?
No.
Madam, anything more to
If
be
Lordship
added?
wants it, I think Lordship can close it.
Think about. You're making any written submissions?
No, my lord.
This much only?
That's much.
Obliged,
Any
Lordship.
further written submissions? No.
I have
You
given a
want-
note already. I had already submitted a note on the last occasion.
Mail, you submitted on mail, madam?
Yes, Lordship. Oh, it was also submitted physically. Mhm. It was also submitted physically, Lordship.
देख लीजिए तो क्या है. Report में नहीं.
On 23rd of February, Lordship.
हाँ? Written submission. ये नहीं, ये आपका वहाँ पे record में. Right, it's here. Record में.
I can send one more.
No, it's here.
Uh,
It's here. They have put it in the serial. Third, members M. Hajorika, Learned Senior Counsel, assisted by Ms. S. Neva. Also heard for the appellant, also heard Mr. B. Deka.
BM Deka.
BM Deka, Learned Counsel representing the respondent. So, hearings concluded. Case reserved for judgment. Have it next week, Mr. Court.
Much obliged.
Mr. Singh,
Lordship.
show me the law which permits that in the event an officiating arrangement is made, the salary of the higher post is simple as that. The
Lordship.
orders that have been passed by this court which you are relying upon does not lay down any law. It's just that somebody has been given, so you are also to be given. This court finds it difficult to follow that. Show me the law, we'll pay. It's basically a
Lordship.
49C, FR 49C arrangement.
Lordship.
And with the condition, with further prescription by them, that you were otherwise not in the zone for that promotion in the normal way.
Lordship.
Then
No, I'm not claiming the regularization and all,
You
but the
cannot.
promotion. I'm
you will not
claiming.
get this also. You leave it if if you're finding it difficult, leave it. We are giving you option. That will not be held against you. But show me the law. Wherein
Basically-
49C, you are entitled to the skill.
Basically, Lordship, I'm relying on this judgment.
This
Lordship, because
does
squarely,
not lay down any law. It only says somebody was given, so that somebody given negative equality, although I did not like it when I was that side, but this side I have to take it.
Lordship, in this case, your lordship was not.
No. Negative equality was something which I did not like when I was that side. But here I can't, I'll have to take it. Just show me the law. That for an officiating arrangement also, you are to be paid the salary. Because what happens here, Mr. Singh,
Lordship.
there would be hundreds. They say 1,000. You have superseded 1,000. I'm saying there may be hundreds or tens
Lordship.
who would be eligible for that post. And this is a state post.
My lord.
Selection is done
My
all
lord.
over the state for all
My lord.
one cadre.
My lord, my lord.
Want to rely on some judgment? Want to
Judgment
do some
was
work?
in the state.
We'll have it tomorrow. Do the homework. Find one judgment for me. I'm with you.
I will.
There are decisions of Mr. Justice B.K. Sharma, Honorable Justice B.K. Sharma against you. 49C, same principal, vice principal, Assam. Right too, but I cannot. I'll get it if I do. You do that exercise for me. You also find out.
My lord.
Tomorrow. Day after that.
I will try.
Liz, upon hearing the parties, list this matter again on March 12, 13, 14, 3, 2024, enabling the parties to bring on record decisions in support of their respective contentions. And see, the law is that you must be eligible for that promotion. It seems that one of the conditions, seniority, you are not fulfilling. Be that as it may. Try to get that.
Seniority so far as is concerned, that
Because,
also I am
see,
not
if
claiming.
If I pay you that, if I direct you to be paid this scale, then the rights of the other persons who would otherwise be having a more better claim than you would be affected. Do you get my point?
I
You have to
understood
Look
you.
it at that line. Also. Look it, come back there after tomorrow.
Item number 9.
My lord, item number 9, my lord, this become infractions, my lord.
How can you say that?
My lord, that promotion has been given to me, my lord.
Given to you?
My lord, it has been, DPC I been promoted.
Who is appearing for the petitioner?
My lord, I'm for the petitioner.
You're for the petitioner?
Yes,
okay. And you appear for the education. This is textile.
Well,
on the pair. This is item number
9, my lord.
T. Zamo, Learned.
T. Tago, my lord.
Tago. Learned counsel for the petitioner submits that the petitioner during the pendency of the proceedings has been promoted to the post of Joint Director, Textile and Handicrafts. So accordingly, no further issue arises for adjudication in the present proceedings, and accordingly, he prays that the petition be closed as having become infructuous. So, prayer accepted, the petition stands dismissed as being infructuous.
Item number 10.
Lordship, time may be given to file rejoinder.
Not a fit case for each other. You argue.
Lordship,
just show me where your rights have been hampered with.
Petitioner has insisted to reply.
No, the petitioner's insistence, we are not bound. You show me the right. Just show me the right. You were given ad hoc on contingency basis. You continued at a lower scale of pay. You were thereafter same place, Pasighat itself, right? It's not that from Pasighat you were brought to Eternal. Pasighat itself, you were made a welfare officer, right? You get a higher pay scale. Now you want to come back as English. They say that the post of UDC has been converted to a welfare officer. What more is left, Mr. Counsel? Just on this. Prepare the case today, tomorrow. No rejoinder. Prepare. I'll not take you by surprise. Prepare. Come back to me. and give me something strong. Right? Tonight you are preparing the meeting. Right? Right or wrong?
No, after 1 week.
Huh?
After 1 week. Lordship.
No, today, tomorrow. 10
After 1
minutes
week.
it takes. It took me 5 minutes.
After 1
It will
week.
take you
Lordship.
10 minutes.
1 week.
No, tomorrow.
I'm not prepared today, Lordship.
No. If there was something, I would have given it, but I'm giving you a chance. Prepare. You're young, that's it. Prepare. Come back. Give me something to change my view.
Okay.
I'll change. A little bit effort from you. Right? Do it.
Lordship.
Yeah, Lordship. Lordship, here in this case, Lordship, this matter may be list day after tomorrow, Lordships. Small rejoinders, Lordships. I would like
This is
file, Lordship.
again with that vigilance clearance.
Yes, Lordship, vigilance clearance.
Mr. Ratan, when have I fixed the other matter?
I think on 15th.
Huh?
14.
14.
Yes, Lord, 14, Lordship.
Let's this matter again on 14.
Yes, Lordship. Much obliged.
Lordship, I was pressing for withdrawal of the matter, Lordship.
Yeah.
Since there is some defect in filing, Lordship.
Same matter where affidavit was shown.
Yes.
Prior to
Yeah.
some of the facts.
And with a liberty to file. Press.
You have a welfare fund here?
Bar association.
Bar Association Welfare Fund? Pay.
This is a village people, Lordship. This petitioners, farmers, regarding land matter, fighting for their land rights. That is why, yeah, that is a problem. Village people.
Compensation.
Compensation. Yes.
On the prayer of Mr. T. Council for the petition submits that he is under instructions not to press this matter at this stage in the present form. That's all. Prayer accepted. The writ petition stands dismissed on the withdrawal. However, liberty is reserved to the petitioners to prefer fresh,
File fresh.
to file fresh writ petition if the occasion so.
Yes.
mandates. Hard deal on the council for the parties. The office note dated 7/3/2024 reflects that the service of
Service
the
has
private
already
respondents is
completed, yeah.
complete. Accordingly, lists this matter for admissions after 2 weeks on a date to be fixed by the ministry.
Obliged.
Hard deal on the council for the parties. Seen the office note dated 22/1/2024. The Atlantic Council, Mr. G. Lawlen, has appeared on behalf of the respondent number 3. Accordingly, the service is complete. List the matter for admission after 2 weeks on a date.
Your Lordship, there is an interim also that may be
The
continued.
interim order, if any, shall stand continued till the next date of this.
Obliged.
Seen the office note dated 7/3/2024. Service on respondent number 7 and 8 is still not complete. Accordingly, list this matter again after 2 weeks with a fresh note from the with an updated status report with an updated note from the registry as regards the status of service upon respondent number 7.
Lordship.
Who is opposing you? Other than madam?
Uh,
Any respondent, private respondent?
Yes, Lordship.
Okay, he has come. Private respondents think he has not appeared.
Yes, he has not appeared.
Right, sir. Argue.
Lordship, in this,
If I've understood your matter correctly, you say
yes, Lordship.
that the respondent having not pursued the degree course
Yes, Lordship.
by taking prior permission,
Yes, Lordship.
that's not maintainable.
Lordship.
I agree with you. It is a misconduct.
Lordship.
But tell me, the certificate is at page 60.
Yes,
Is
Lordship.
this university a recognized university?
Lordship.
Madam, is this university a recognized university? Venkateshwara Open University, Itanagar.
Yes,
It's a recognized university?
think it's a recognized Lordship.
Then
Lordship,
they will proceed against her if required for violation of the service conduct rules.
Lordship.
You follow the CCS conduct rules.
Yes, Your Honor.
They'll follow, they will draw proceedings, but how can the degree be set at naught? I am bound by my own decisions, unfortunately. The similar matter in Guwahati,
Lordship.
wherein B.Ed degrees were pursued
Yes, Lordship.
without taking prior permission, or MA degrees were pursued without taking prior permission. Following my Lord Justice Bhujarburwa's judgment in an IA, I have held that the petitioner may have exposed herself, or the person may have exposed herself to proceedings for violation of the conduct rules. The degree being from a recognized university, that cannot be invalidated. Because what you're doing, what you're asking for,
Lordship.
would amount to invalidation of the degree. Invalidation of the degree can be done only in two counts. One, that university is a bogus one.
Lordship.
Two, the university cancels it. No other authority has it. Now what do you have to say?
Lordship, in that case, Lordship, the issue here is, Lordship, in various cases, Lordship, where the degree has been obtained without seeking prior permission from the competent authority. In the case of Ravindra, Lordship is aware, Ravindranath Burman.
No, these things have been watered down.
Lordship.
These things have been watered down.
And in coordinate bench of, I'm relying on that two
judgments have been watered down. Your allegation is conduct rules, violation of the conduct rules.
Lordship.
But violation of conduct rules is a misconduct.
And this
but the degree cannot be invalidated.
Yes, Lordship. These issues, Lordship, this issue I have brought up before the departmental promotion committee prior to conduct of the departmental promotion.
They did not give anything to you. They've just proceeded with that.
Yes, Lordship.
Rightly so.
And in those judgments of the coordinate bench, then impal bench, Lordship, there they have the court has specifically said that the degree course which has been obtained unauthorizedly, that cannot be considered.
Has the court in those judgments examine the fact whether that violation of the conduct rules,
yes,
because it's in the conduct rules,
yes,
you cannot proceed for any, show me that, the conduct rules. Indian conduct rules.
Here, Lordship, in this case, Lordship, the degree which was unauthorizedly obtained without
unauthorizedly obtained, sir, it's
yes,
a degree obtained from an open university. Open university does not mandate the person to go there and study. One. Two, the degree may be in violation of the pursuit of the degree may be in violation of the conduct rules. No issue on that. But that will not invalidate the degree.
But Lordship, the issue here in this particular matter, Lordship, if your Lordship may allow.
Please.
Lordship, here in this case was that the court has directed that the degree which has...
This is something I don't like. You must be firm.
Lordship.
Go ahead.
So, Lordship, I was submitting that the degree which has unauthorizedly obtained, that here it has directed that it should not be considered.
Where?
Lordship,
show me.
Lordship, this is a judgment from then coordinate bench of Impal, Lordship. Here it is discussed Ravindranath Burman versus Guwahati High Court and another and various judgment rendered by Honorable Apex Court, Lordship. Lordship, for a moment, I would like to take Lordship to para 9, Lordship. Page 5, Lordship. May I read, Lordship?
It's okay. Where are the conclusions?
Conclusion, Lordship, it's last page, Lordship. Page 5, 23, para, Lordship. For the reason discussed above, the state respondent are directed not to consider the private respondent number 4 for promotion to the post of so-and-so based on the graduation certificate obtained by him unauthorizedly or by committing misconduct, Lordship.
Mr. Counsel, the distinguishing factor is at para 30. Read para 30.
From the facts?
No doubt about this judgment. It's a misconduct.
Lordship.
But that will not undermine the degree.
Lordship,
They can proceed against her departmentally, impose penalties, and thereafter maybe her promotion also can be interfered with. But
Lordship, in that case, I may be given some time, Lordship. Maybe tomorrow, if the matter may be taken up tomorrow.
and the degree that was pursued both in case of Rabindranath Burman, I know that personally because maybe I appeared in that matter. And here where regular courses, you get my point?
Yes.
And here it's an open university.
No, but Lordship, she has appeared as a regular student, Lordship.
But open university, you need not go daily to do classes.
Lordship,
that is the beauty of an open university.
Of course, Lordship, that is there, but she has also received scholarship from the university as a regular student. That I have also enclosed in the writ petition.
Let them. But this court is of the firm view. Misconduct, they can proceed, but degree cannot be invalidated. That is why my first question, whether this is a recognized university. Recognized university, you cannot change. Because if you read further, you'll see that 75% attendance would be required.
Yes, Lord.
That was said to be, cannot be achieved because it's a 10 to 5 job.
Yes, Lordship.
And that is also a maybe morning school or evening school.
Lordship.
It cannot be done.
Yes, Lordship.
Examine. Tonkesh or not. Search will get it. Tonkesh or not. Tonkesh or not. DM degree without permission proceed. You can ask Mr. Vikas, or she will also find it. Our EB, latest take here was coming. Because on the prayer of the learned counsel for the petition and not objected to by the respondent, list this matter again after 2 weeks. Right.
Deeply obliged.
But the learned counsel for the petition and also the learned government advocate again, seen the office note dated 7/3/2024. The service on respondent number 4 is not complete accordingly.
My lord, for private respondent, I am appearing.
Go.
Today I have filed my wakalatnama.
Okay, okay. Continue. Heard Mr. So-and-so, Ms. So-and-so, so-and-so. Mr. So-and-so, learned counsel appears as ended appearance for the respondent number 4. Accordingly, service is complete. List the matter for admission after 2 weeks on a date to be fixed by the ministry.
Obliged.
You file your affidavit.
Yes,
In the
ma'am.
meantime, the respondents are at liberty to bring their respective stands on record by way of filing affidavits. 3 weeks then. Okay?
3 weeks. Obliged, madam.
Because this is done.
My lord.
Seen the office note dated 31/1/2024. Service on respondent number 6 and 7 is complete. Accordingly, list this matters again after 3 weeks. The respondents are at liberty to bring their respective stands on record by way of filing affidavits in the
My lord, till just time earlier interim.
the interim order passed earlier to continue till the next date of this.
My lord. Deeply appreciate.
You have appeared. नाम लिख लीजिए, Mrs. So सबका नाम लिख लीजिए. As a entered appearance for respondents.
Deeply appreciate.
Seen the office note dated 27/2/2024. Respondent number 5, anybody appearing? You are appearing? Okay, fine.
We are finding all.
So you are ready with the case?
Also, we may take some time.
Because the interim order was to be considered today. And you waited till the last moment to come.
We need some time to go through the report.
List this matter again on 26/3/2024. The prayer for Mr. Swanso, सबका नाम लिखिएगा. Mr. Swanso has appeared for respondent number 5. Has entered appearance for respondent number 5 too. Also. List this matter again on 26/3/2024. On which date the interim prayer would be considered. So, it is provided that the respondents may bring on record their respective stance by way of नहीं चाहिए उसका the interim का कर दीजिए. हाँ, ये लिखिए. The respondents may bring on record 26 नहीं तो first week कर लीजिए. Let it be on 3rd. The respondents may in the meantime bring on record their respective stands by way of filing their respective affidavits. Also, the interim order passed while order dated 22/12/2023 shall continue till the next date of this.
Deeply obliged.
Yes.
This is for compensation for illegal detention. Madam.
You are released.
Release, madam.
What happened to the case?
Yes,
Main case.
main case, maybe charge sheet is yet to be filed. Madam.
Charge sheet not. Who is opposing it?
Private responsibility is also there, madam. The IO who has arrested me.
IO is also because it will be basically the IO.
Yes.
She has filed an affidavit also.
Yes, madam.
And this court required her to submit an apology.
Yes.
As it may in her own way, she has made some prayer for apology.
Yes.
Okay. Who is appearing? Anybody? Huh?
Governments.
But the private respondent is required. If you pass some order, you will take a private respondent.
Private.
Okay. Naam likhe, Subhuta Pinda bhi likhe. None has appeared, entered appearance for, none appears for the respondent number
4.
4. Accordingly, as a last chance, list this matter again after 2 weeks, 3 weeks, date to be fixed by the registry. On the next date, in the event the appearance is not, in the event none appears for the private respondent number 4, this court will proceed to consider the issue as arising in the matter in absence of the respondent number.
Yes. All right.
Yes, madam.
No, by this petition, the petitioner is claiming for 2 years of salary, which has not been paid to him by the government. And according to the CCS rules or under any of the acts that govern a government servant, suspension can only take place if there is any misconduct on part of the petitioner. However, in this case, there was no misconduct, nor was he served any notice or anything, but his salary has only been withheld only due to the illegalities within the department and due to the conduct of a deputy director that was serving back in 2020. The basic
What is the period, madam, you are claiming?
from from February 2020 to March 2022.
February
2020 up until March 2022.
22.
Yes, sir.
Now you are getting your salaries.
Now we are getting the salary. So on 21st March 2022, the petitioner herein, he was finally released from his farm, from Jumbo farm where he was
Show me the
serving.
orders. Take me to the orders.
At page 43 on.
Where is your transfer order?
Transfer order is
Page
at
19.
page 19.
Where is your name?
At serial number 14, Shri Borik
14.
Parme, 14.
Borik Preme.
Borik Parme. He was transferred from Jumro farm to Palin. However, this transfer order was made before completion of 2 years of his service in that particular
Challenge
farm.
that.
And that was challenged before this honorable court, YWPC number 42. And he was given the liberty to approach the authorities by filing a representation, and the same was done. Thereafter, he was allowed to stay in the farm.
Madam, take me through. The representation is okay.
The order of the honorable
So
court
page
is at page 21.
27, you were allowed to remain at
Jumlo
farm. Up to March 20.
March 2020.
Okay. Then what happened?
Thereafter, the petitioner had submitted a joining report at page 28 that he'll be joining the Jumlo farm back again. However, he received a letter from the however, this joining report of the petitioner was not accepted by the deputy commissioner. And then there was some deputy director, sorry. And at page number 30, Honor, the petitioner herein was again transferred because the earlier transfer was
so what
retained.
happened from the period till 13/2 to 8/6? Where were you?
At Jumlo farm itself.
You were working.
Yes, Your Honor.
Then you say you were not allowed to join? Okay,
He
fine.
was not allowed.
8/6, what happened?
Thereafter, he was transferred from Jumlo farm to Geku at serial number 3 under Upper Siang district. After this transfer order was made, Borik Parme, the petitioner here, again placed this particular letter before the deputy director at page number 33, saying that he's furnishing the transfer order dated 8 June 2020, and he wanted the deputy director to release him from this farm so that he can go and join the new place of posting at Geku. However, the deputy director completely denied releasing the petitioner from the farm.
Okay.
Thereafter, many months passed by.
Any order passed to this effect? No.
Pardon, Your Honor?
Any order that he will not be released? No order was passed.
No order was passed. However, there were communications from him to the Secretary of Horticulture that he will not be able to release the petitioner because he's not under the. No, Your Honor, not in this petition because they had filed the petition later on.
In this court?
Yes, Your Honor.
Against that, what was the issue there in that petition?
Because at the end, on 21st March 2022, the current petitioner hearing, he was released. Only after the incumbent deputy director was was suspended from his post. So despite multiple directions from the secretary.
What was the other proceeding you have initiated before this court? One is against that transfer order.
That case was initiated by deputy director because he was suspended from the department.
Okay.
And he was claiming for his salary and.
Why was he suspended?
He was suspended on.
Nothing to do with the petition.
The suspension order is next hearing.
Nothing to do with the petitioner here.
No, because of that itself.
Oh,
because of the petitioner. Page 42, Your Honor.
Have you made him a party here?
We've only made the deputy director of Jumlo Farm as a party. Although right now he's not
Here there
serving.
is nothing said that because department proceedings have been contemplated.
Page 42.
It only says contemplation of department proceedings. It does not say the allegation. It does not state the allegation
Yes, Your Honor, and that itself was challenged
by him.
by the deputy director.
What was the stand of the government there? Because of
It was-
your case, they have not.
Yes, Your Honor.
Do you have anything to substantiate that? Have you made any statement to that effect in the writ petition?
In that
he-
particular writ petition, we filed our affidavit, but the record of that is not annexed in this.
I'm not on that. Your contention is that order at page 42 was issued because you were not being released or actions
Yes.
that were taken. Have you made any statement to that effect in the writ petition?
In the writ petition?
Hmm?
Yes,
This
Your
writ
Honor.
petition. You have not made
I have, Your Honor.
para 12. To the effect that because of non-releasing you, the deputy director was placed under suspension. To that effect, there is no statement.
No, no, although the orders of the secretary and the director of horticulture itself states that the illegalities of the deputy director at page number 45, if I may read, Your Honor.
I'm on that.
This is an order passed by the secretary of horticulture, wherein the grievances of the petitioner has been stated by the secretary. And
So
it is
this
mentioned at
the-
page number
this is
46.
Your foundation.
Yes, Your Honor. Page number 46. Sri Loki Iring, who was the deputy director back then, was given sufficient time of 2 full years to release Sri Borik Parme, HDO, and mend his conduct before his authority. However, Sri Loki Iring, deputy director Jumlo, continued to defy the government order and render the service of a HDO jobless for 2 years. Considering the misconduct and indisciplinary act
Okay,
indulged in
done.
by
What is the stand of the authorities in the affidavit?
they have not denied the contention of the
Lordship, the
petitioner,
fact
however-
is that the present deputy director has no idea, and some of the things happened because the file got missing due to the action of that earlier.
That cannot be a reason.
No, but that is why.
That cannot be a reason, Mr. Counsel. Where is his service book?
Service book
has
got
been
lost,
received.
Lordship.
Reconstruct it.
That is why, Lordship,
Reconstruct it.
give
It's
us a
not
time.
It's not unknown.
We'll
In service jurisprudence, you can always reconstruct a service book.
we'll reconstruct, but Lordship, give us some time, Lordship. Up to the, I can submit, Lordship.
After this order, this is what I was looking for.
Yes, Your Honor.
Page 45 and 46.
Page 45.
How can any blame be put on the petitioner's shoulder? Hmm? How long will you take to clear this,
Lordship,
regularize this?
Lordship, give us 3 months.
3 months time.
Lordship.
I'll record your submission.
Lordship,
That
that
within
was,
3
I
months-
was instructed. Lordship.
Instructed. We'll not say anything else. We'll only put page 45, 46, your submission, that within 3 months, you will reconstruct her service book and release all those areas regularizing that period. Run.
With the
Yeah.
updated service book, Your Honor.
Huh?
Updated. Because there are dearness allowances of the petitioner, which is
That will-
lesser. He's receiving lesser than his computer.
Your name?
I,
William नाम ले लेना. You're for the
Respondent number 1, 2, and
standing
3.
counsel,
no, additional senior commander.
additional seat. For respondent number,
1, 2, and 3.
all.
Four.
1, 2, no, no, 2 horticulture have their own.
You're for the chief secretary.
Lordship,
No, no,
1 and
initially
4.
there was a standing counsel for the horticulture department. However, they are not appearing in the case from earlier.
From
So
whom did you get your instructions?
Lordship, respondent number 4
Hmm.
and this director.
3 and 4.
3 and 4.
So you are appearing for all.
All, Lordship.
Appearing for all. Regularize it as on duty. Because your own secretary's contention at page 45 and 46 reflects that only because of the superior officer's thing, he was not being released. Right?
That is why the disciplinary action was contemplated against the
That you've done a right thing. This is the way it should go. But now, the victim has also to be redressed. Where is your prayer, madam?
at page 17, 16, 17. We're also claiming for the cost of litigation because of the unnecessary harassment. Unless and until because there are multiple representations, Your Honor, made on behalf of the petitioner, and they still did not release. They had on multiple occasions, they had given the representation.
February 2022, okay, we'll test.
March 2022.
We'll test you on this. February 2020 to March 22, you were without salary. How did
COVID.
you survive?
During the COVID.
How did you survive?
Because of loans, Your Honor.
Why didn't you come before this court?
That was
Why
the
did
period
you
of
not
COVID.
come before this court before? When did you come?
2022.
Once
July.
the action was taken, regularized, you approached this court. Now tell me.
21st March.
Tell me, your grievance is from February, March itself, 1 month. You can't survive. You're an employee. Surviving on salaries. How could you? 24th June, you came. Right? Madam?
Your Honor, at page 51.
Now tell me about this. I'll decide the quantum. Don't worry, but tell me on this.
On 17 June 2022, prayer for payment of salary,
Fine.
26 months.
How did you survive beyond 1 month without salary?
He has taken loans from various.
Where is the material? Where is the material? If you have taken loan, have you taken permission from the authority? Without permission, can you take loan?
No, not from bank or institution,
Actually, from
but from
private sources.
private parties, yes.
Private sources. Show me. Where is your statement?
That has not been annexed here.
What prevented you from coming to this court? You should have been here the next day.
Because Your Honor, during
March itself, you should have been here.
During
April,
the-
you should have been here. There can be an adverse presumption against you. You were not in requirement of the salary.
Your Honor,
Maybe
because-
you were taken well care of.
Your Honor, if I may make my submission. During the 2020, the period when he was not getting the salary, at that point of time, COVID was at its height, Your Honor. And at that point, there were a lot of, what do you call them? Curfews. So people were not allowed to leave from their houses, like
When
let
did
alone.
COVID finish?
2021, in the month of May, also there was
Why?
curfew.
June? We were having courts.
Yes, Your Honor.
We were having courts. Courts were open, inter-district transports were open
Yes.
by May.
Yes,
So from May, 1 year why he had to wait?
because maybe he had hope, Your Honor, that he will get the relief, because
cannot have
earlier
He
also.
cannot have a hope, madam, because the deputy director was still sitting there.
And there were actually positive responses from the director and secretary. That is why he was in the
There
hope
is
that
no
he would get
positive
the.
response, madam, beyond page 45 and 46. That is the end of the matter.
No, there are multiple orders, Your Honor.
Where?
From the secretary and director to the deputy director to release the petitioner. They were
No,
continuously
release
directing.
is different. Release is different. Payment of salary.
And for grant of MACP also, the petitioner has written multiple representations.
Dispose of. We'll allow them 3 months, madam. That part, leave it. That part, leave it. Don't take this court to that. Anything? Khatam? We'll allow your repetition, give them 3 months.
Your
time.
Honor,
Then
we have paid for the salary
Full
along
sal-
with
full
interest.
salary, full
Along with
salary.
interest, Your Honor.
Go to the civil court.